The file has come on 7th of May. Kindly, my lord, add this matter.
Let me see.
Yes, my lord, two matters.
May I,
Two matters. Same.
my lord, may I permit to mention for a
For motion matter, just
inclusion,
stand over the screen.
inclusion
This
under
is urgent motion, my item.
I shall see, sir.
I have served the notice to the other side also,
For
mentioning for inclusions
inclusion of for under
under
hearing.
new motion.
New motion, just hand over the slip.
I
Will
have
be taken up in as per serially.
great.
Order of demolition has been passed on this matter, my lord. My lord, previous
Order of demolition has been passed by which court?
petition of 19th, my lord. We had filed this writ application. After filing, we had filed this writ application challenging on previous demolition notice passed by litigation authorities. Now, my lord, when this matter was filed, during this pendency of this matter, my lord, parallel proceeding was drawn up. We mentioned that this matter is pending before your lordship, my lord. Still, they have passed one demolition notice just yesterday without giving any reasoned order whatsoever, my lord.
What do you want?
My lord, if your lordship kindly hears it out before 19th, my lord. Demolition is scheduled on
I
19th,
cannot.
my lord. Kindly.
Under which authority has passed the order of demolition?
Litigation department.
Yeah, according to them, we have made illegal construction.
Yes, according
Over
over the embankment, but the land is ours. We have documents to show that, my lord. Kindly hears it out, my lord, before 19th, any day, my lord.
I will serve notice.
I shall serve today itself, my lord, if your lordship kindly
It has been filed.
Yes, it is filed. File is in this court only, my lord.
ওটা নিয়ে নাও তো, ওটা দেখে নিয়ে ফাইলটা নিয়ে আজকে হচ্ছে আপনার কত মে, আজকে মে 14 নাকি?
Yes, my lord.
সরি, আজকে হচ্ছে মে 14, yes. 19 মে রাখো।
19th May, my lord, 19th May, can it be taken at 10:30 because 19th is only scheduled for demolition, my lord, or else, my lord, 16th, 18th, Sunday.
16 মে তাহলে
16th.
16 মে তখন আমরা অ্যাডজন মোশন গুলো নেব।
My lord, can it be fixed at some time, my lord?
19 May,
My lord, then
the
kindly.
top of the list under the heading motion,
Grateful.
fixed motion, whatever.
My lord.
May I be permitted to make one restoration application?
Restoration application.
My lord, I am praying leave, my lord, to move as an urgent basis because the construction made by the respondent number 9 over the PW.
Cannot be
My
granted,
lord,
sir.
already, my lord, 10-1 proceeding stop work notice has been given to the respondent number 9. In spite of that, if your lordship kindly see for a moment the construction, more than 100 workers are
No, you
engaged.
file there.
My lord, any date before vacation, any date as your
Not
lordship
possible,
convenience. I served and
You
came back.
file it first, thereafter I shall consider.
May I be
Great.
permitted to mention for inclusion in the old hearing matter? File is
Only hearing, if it is within my determination, give the slip. I shall see. I will serve notice.
yes, I already been served and file is lying in this court.
Madam, for hearing matter, old matter, madam, I have.
Within my determination? Yes, madam.
Permitted to mention 6 analogous matters which the matters were heard by the earlier bench, my lord justice.
Hearing matters.
No, my lord, this matter was fixed today for orders, and there was a direction. If your lordship kindly sees this last order,
আজকে আছে?
matter is not there in the list, but it was fixed to appear today as under the heading for orders.
Mention after vacation, not before vacation.
Your
Yes,
lordship,
Mr. Sengupta.
madam, the date was
Mention
fixed
after
today.
vacation. জানি, বুঝতে পেরেছি। Mention after vacation. Mr. Sengupta.
After a long time, my lord,
Okay, Judge, detail
I have got a chance to appear, my lord. My lord, here, my lord, there is a contempt application. And contempt application, Honorable Justice Mitro, my lord, has no, my lord, authority to take up any recalling application connection with the main order. So, my lord, recalling application has already been submitted long before 2017. So, he just made an observation, Mr. Sengupta, the judge, the honorable judge, taking up the land matters. My lord, he has the authority, and I have checked it. My lord has got the authority to hear the recalling application. So,
Recalling of what, sir?
recalling of the parent order passed in a dispose of writ petition that is pending since 2017. So, contempt is
Recalling of a
application of an order passed by the then Honorable Justice I.P. Mukherjee which is according to me, subject to my lord's approvals, when my lord will hear me, that it is absolutely void ab initio, because this is totally contrary to law. And state was not represented at that point.
What is the urgency mentioned after
Urgency,
vacation?
because urgency, my lord, the honorable judge just gave me 1 month time. Mr. Sengupta just ensured.
So after vacation mentioned.
kindly fix it. That is my humble side. So I have served a notice. Notice I have served. Today I will mention.
I don't know what is the nature of the order.
Nature of
Your order is there. Copy of the order is there. Server copy of the order.
last order.
Huh?
Last order, there was no such order. Previously, there was an order.
So in the event you are agreed with that order, why have not prepared an appeal?
Well, I have, because in a contempt application along with recalling application was taken up for hearing before the Honorable Justice Mitra. And Honorable Justice Mitra made an observation, Mr. Sengupta, I have got no authority. Only I can hear the contempt application. So
Very good, I shall see.
Yes.
After file টা আনাও তুমি আমাকে দেখিও তারপরে after vacation note রাখো. Yes, sir.
Kindly fix one date, my lord.
Let me see.
My lord, kindly look the file.
May be permitted to mention one recalling application of your lordship's solemn order dated 5th May 2025. My lord, the sole ground of recalling is that the private respondents,
Mr. Sengupta, please allow me to.
though they were not represented on that day, their names have been recorded in the order. And number two, my lord, is that this is an order where your lordship, by considering the provisions of the West Bengal Highways Act, section 10(3), passed a detailed order, directed the concerned authority to conduct a hearing, and where private respondents will be participating. My lord, that hearing is scheduled on 15th. That is the urgency. My lord, we were not properly represented, though we were the party. Suspiciously, our names have been recorded. The learned advocates who was not appearing before this court, their name have been recorded, my lord. That is the ground of this recalling, my lord. Can it be taken
Again,
up?
under the heading application, have you served?
Yesterday I filed the application. I will serve it today and to the learned advocates.
Without service, I will not have.
I will. Can it be taken up tomorrow, lordship?
That I cannot see.
Lordship, may.
See?
My lord, may I be permitted to mention on matter? On matter, lordship taken up.
হবে under the heading application, হ্যাঁ?
ওই application টা
Lord,
number.
may I be permitted to mention?
দেখি একবার ফাইলটা দেখি ফাইলটা please.
Well, this is the copy of the application. The order is annexed, my lord.
Private respondent number 10 and 11 are represented.
They have been shown, they are represented.
Huh.
My lord, there is a specific allotment in paragraph number 5 of the
Mr.
application that
Asif Iqbal and Mr. Devdeep
Devdeep
Mondal for the
Mondal,
private respondent.
they were not present before the court. That is the contention.
What are you saying?
My lord,
This
that-
court heard the learned advocate for the read petitioner, the learned advocate for the respondent state, as well as learned advocate for the private respondent
my
number
lord,
10 and
that-
11 at length.
that is the
This is a serious aspersoning is the
my lord,
court.
that is the application content of the application. My lord, has come.
Sir, this court order has been passed in open court. What are you saying?
My lord, I understand, but that is the content of the application, my lord. So I cannot help. I was not present. I don't know. I have been briefed in this matter, my lord. Mr. Devdeep Mondal is the advocate on record of this particular, whose name has been recorded. He is the advocate on record of this application, my lord. Under the instruction of the learned advocate on record, I make this submission, my lord. He himself is the-
Sometimes mistake occurs on the part of the AR court
I understand.
while
Understood.
printing the order.
I understand.
But when this court has consciously recorded that this court has heard learned advocate for the read petitioner,
I
learned
understand.
advocate for the respondent state, as well as learned advocate for the private respondent number 10 and 11 at length, you are saying he has not appeared.
He has, that is the.
This is serious aspersion against the court. How the court will function, sir?
I understand the difficulty and predicaments, my lord. That is the only
জানি
thing.
না ভাই আজকাল সব কি সব ঘটছে
Kindly,
কিন্তু মুশকিল shall start a attendance register of the learned advocates.
I understand it.
Sir, what are you saying?
But I understand the difficulty, my lord. That is the
What difficulty, sir? Am I supposed to open an attendance register of the
I
court?
my lord, it's not. My
And
lord,
all the learned and all the learned advocates will make their signature.
no, my lord, that's why, lordship, there is an abutment, specific abutment, my
Oh,
lord,
after vacation দিয়ে দিন।
that,
After summer vacation
it
থেকে
has to be examined from the
Very good.
this live streaming.
Very good.
It is
Sir, may I be permitted,
grateful, my lord.
my lord, may I be permitted to mention a matter taken up by your lordship on order 7. My lord, my other side was Mr. Dhod. He submitted, my lord, the report. On the basis of the report, my lord has dismissed the application. My lord, actually, my lord, authority has acquired 9 dismal of land for the construction.
What is the matter about? Why you are mentioning?
My lord, there has been all dismissed for default on the basis of the, my lord, the report.
Dismissed for default or dismissed?
Dismissed,
Ah.
my lord. Well, actually, my lord, authority has acquired 9 dismal of land for the construction of Nondigram Primary Health
Dismissed
Center.
for dismissed, go and file an appeal.
My lord, let it be appear after
Recall.
to be mentioned, and my lord.
Why? Sorry.
My lord, may I be permitted to mention, my lord, that the before vacation, my lord, I pray that your lordship will take new motion at the second half, my lord. Otherwise, my lord, it is our, my lord, convention before vacation, my lord, 7 or 15 days, my lord, before, always, my lord, our honorable judges, my lord, took the motion, my lord, first. So, my lord, I pray if you are with the, my lord, your kind approval of the.
Because
my
it
lord, I am
gives
not my-
it gives very pain that the lawyers are appearing. I'm recording their names and
I am
still
sorry,
they are saying
on behalf
that I have not appeared.
I am very sorry for that much. I'm very
This is
sorry.
very unfortunate. We have never
Huh?
heard this. Never seen, never heard this.
My lord, that is your
It's
lordship.
a serious aspersion against the court. How the court will function, sir?
Very unfortunate. I
It happens sometimes on the part of the air court.
The
Petty,
name
but
of the before.
At the heading.
She was recorded hard, the learned advocate. That is why this is very.
All right, sir. Mr. De, I shall consider.
Your lordship will consider my.
Yes. Call the matter.
In this matter, I am appealing also the petitioner.
State.
Why it is placed under the heading to be mentioned?
Because firstly, on 29th of January
Give me a second.
2005,
Give me a second.
My lord, I appear for the state respondent.
on 29th of January 2025, my lord,
Give me a second, sir.
sorry, my lord.
Yes.
But on 29th of January 2025, Lord, when the matter was taken up by my lord, my learned friend for the state appeared that he got the instruction. On that date,
You are Mr. Chaudhary.
yes,
Lordship.
he appeared, kindly, sir.
Yes.
He appeared and paid for, but he was directed to file affidavit in opposition within 2 weeks and reply thereto by a week by us. Because then he did not file the affidavit in opposition. Again, the matter was appeared on my lord 7th of March 2025 before my lord. When at the instance of my learned friend for the state, a time was given to
Extend.
file the affidavit in opposition.
So where is your
Till
opinion
date-
opposition, sir?
May I submit,
Till
lordship, the
But
instant
no,
case.
what I am saying,
My lord, may I submit?
till date, as no
Give me-
My
affidavit
lord,
in
the instant case falls as it appears from the writ petition, falls under the DM Purva Midnapur and Anandakumar PS. In spite of my best efforts, lordship, I am unable to get any instruction from the DM authority, although I have got instruction from the Nandakumar PS. My lord, may I submit, lordship? My lord, they are saying they have no role to play, and whatever my lord will pass order, they will carry out the same lordship. My lord, since it is an old matter, 30 years back, some officers are not there.
So
My
you will not file any affidavit in
Lordship,
opposition?
I am a total handicap, Lordship.
So on the
They are-
basis of this report, I
Yes,
should
Lordship,
dispose of the writ petition.
Lordship,
You have
they are,
served a
they are
copy.
unable to give any
In that event, can I have a copy of the report?
Yes.
Let me give a copy of the report so that it can assist, I can assist my lord. My learned friend has filed the affidavit in opposition.
I appear for the Union of India, and I have got this brief yesterday in the evening 6 p.m. because one of the learned judge, my lord, elevated to the bench, was briefed in the matter. Now, my lord, I have been briefed. Your lordship kindly fix the matter after vacation, my lord, with the
Any date at any.
reminders, repeated direction.
What is the predicament on the part of Mr. Chaudhary for not appearing on the last occasion? You didn't appear on the last occasion on 7th for April.
Lordship.
You have been specially appointed by
Yes,
the
yes,
legal
yes,
remembrance.
yes, Lordship.
But what is your predicament on the last occasion? Why have not appeared?
Lordship, perhaps on that day I was not here, Lordship. It was my mistake, Lordship.
Also on 7th of April, my learned friend did not care to
Course of
appear.
hearing.
My lord, the matter of 93. Today we are in 25, Lordship. 32 years old, Lordship. I repeatedly asked.
I shall see, sir. I shall see.
Okay, start course with the court.
My lord, here for the petitioner, my lord, it is appearing at my instance in this matter, my lord. My lord, I'm seeking for the leave, my lord, to withdraw this application to file it afresh, my lord, because of there being some technical
It
problems.
is submitted on behalf of the writ petitioners.
This has come at my instance for the extension of the interim order. Last of such interim order is extended on 13th February 2025.
Readings are complete, Mr.
My
Khan.
my lord. Now, my lord, on the same issue, my lord,
When it is going to be expired on
my lord, tomorrow.
tomorrow. Asun.
Item number 4, I am appealing for the respondent, my lord. I have got a serious objection as to the extension of interim order. Why, my lord, I will satisfy your lordship. Your lordship can kindly see the affidavits are completed. As many as 8
fix a
times,
date
not
for
your
hearing.
lordship, kindly give me patient hearing. Your lordship, I know your lordship is very calm and quiet. Give us accommodation. 8 times, as many as 8 times, despite there being an order, the matter has to be placed for hearing. And this is an unauthorized occupation of the government land. Affidavits are completed. My lord, your lordship, give the extension of interim order, but fix the date for hearing.
That will do. That I am going to do, sir.
Do your lordship do it?
Asun.
Immediately after your 8 times they have taken the extension of interim order, occupied. Changes, the matter goes down. Again, they come with an application or make a verbal approach before the court that let there be an extension of interim. Like this way,
That
as
is my prerogative. I am
not
not
that,
taking
as
anything.
many as 8 times they have got the extension of
Let us
interim.
hope for the best, sir. Let us hope for the
No,
best.
my lord, but the the earlier matter also may be fixed at 2 p.m. my lord, and with the because the issue involved in the both are same, and your lordship
Unauthorized occupation
Number
of the
3 and
government.
4.
3 and 4, my lord, issue involved has already been dealt with by your lordship.
No, it was
Yeah,
initially heard by Justice Subra Ghosh.
No. Tell me, item number 3 and 4 are identical matters.
Identical, same issue involved.
তাহলে একই ডেটে রাখো
Yes.
একই রেখে রাখো ওই 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 একসাথে রেখে দাও
And my lord, may I?
হ্যাঁ তাহলে এটাও তো বলছি একই আইডেন্টিক্যাল ম্যাচ
Yes, yes.
হ্যাঁ কোনটা না একই দিনে রাখো 23rd রাখো তাহলে 23rd জুন আর কিছু লিখো না 23rd জুন ওই উইথ দি মার্ক 2 PM আর আগেরটা উইথ দি মার্ক 2 PM করে রাখো
Deeply obliged, your lordship. না, ওটা monthly subscription করেছি।
Lordship, item number 5, I'm appearing on view of the petition, your lordship.
I am
On
for the
the
state respondent.
last order, your lordship. The
interim order is expiring on
tomorrow.
you are for the
Yes, your lordship.
Lordship, I beg to appear for private respondents number 5 to 7, your lordship.
stop pleadings are complete
Lordships, kindly come to the order passed by Honorable Justice Aniruddha Roy, order dated 12th February 2025, your lordship.
yes
Kindly come to page 3, second para, your lordship.
yes
Page
sir
3 of the order, second para. Lordship, kindly peruse the order, your lordship. The appellate authority was directed
report has been submitted
report I have
Lordship is handed over right now, your lordship. Today,
ইকো হচ্ছে কেন শুনতে পাচ্ছি না Yes.
Lordship, the report as was directed in the last order, it is served right now in the
My
court.
lord, I have handed over the
Today itself, right now.
The report, give the report.
yes, my lord.
Yes.
Ashun.
Right now it is submitted, Your Lordship.
Yes. Report, Mr. Dei has submitted his report.
বিকাশ আছে নাকি ওখানে?
শুনতে পাচ্ছি না বলে, শুনতে পাচ্ছি না।
The writ petitioners may be given the
Lordship,
opportunity to.
Yes.
Lordship, with this report, the matter is ready for hearing. It is identical with 3 and 4. Kindly keep it on 23rd June for hearing, Your Lordship.
Lordship.
23rd June.
Yes, Your Lordship. 3 and 4, it is identical with 3 and 4, Your Lordship.
My lord, 3 and 4, my lord, that is
3 and 4 are different matter,
another
Lordship.
my lord.
This is a different matter.
I shall fix a separate date.
Senior
What have you got to
Lordship.
say with regard to the exception report?
Lordship, we have received this report right now. We have to consider it, then file an opposition to it. That's why we need some time. And
What you want? You want to file exception?
Yes, Your Lordship.
okay.
I'll file it only. I'll beseech Your Lordship that the matter is pending for a long period of time, Your Lordship.
I'm making my best possible endeavor, sir.
Lordship.
Please kindly cooperate. This
Lordship.
court is this much I can assure. To the
Lordship.
best of my ability, I try to dispose of the case.
Lordship.
So please cooperate with me.
Lordship.
In courts of hearing, Mr. Dei, learned additional government pleader, appearing on behalf of the respondent state and its functionaries, has submitted a report dated 26/9/2024 as prepared by the Assistant Engineer PWD Kharagpur Subdivision. Stop. Let the report dated 26/9/2024 as submitted by Mr. Dei be taken on record. Mr. Dei is hereby requested to supply copies of such
Lordship, with the greatest of respect, Lordship, the report was supposed to be filed by the appellate authority himself, Your Lordship. If Your Lordship once again sees
I shall consider on that day. Mr. Kiriglam, such report to the learned advocate for the writ petitioners and to the learned advocate for the respondent number 5 to 7, preferably within 2 working days from today, if not served in the meantime. Stop para. Liberty is given to the writ petitioners and the respondent number 5 to 7 to file exception to such report dated 26/9/2024 on or before the adjourned date. However, advance copies of such exception shall have to be served upon the learned advocate for the state at least 3 days in advance. Stop para.
Lordship, if I may make one submission, Your Lordship.
The interim order has passed earlier. It is extended till the last day of July 2025 or till further order, whichever is earlier. Stop. Let the matter be listed on June 25, 2025 under the heading for hearing.
Lordship, if I may submit one thing, Your Lordship, this last order was passed on 12th February, but this report is dated 26 September 2024. So this is an older report and they have not provided a fresh report as per the last order
I
of
shall consider on that.
Lordship.
Mr. They kindly check it.
Gratefully, Lordship.
Number 6.
Who is for the writ petition?
Well, the contempt application. Well, I am appearing for the petitioner.
Who is for the petitioner? Order has been complied with.
My lord, there was a direction to pay arrears of pension, my lord. There is a 60-40 share of the municipality and the state.
Who is your leading counsel?
Lordship, there was a direction according to last order that to submit a report.
Give me a second.
Change হয়ে গেছে এরা সব। নামগুলো চেঞ্জ না করলে কি করে মামলা হবে? দাদা আছে তো? আমি চেঞ্জ হয়ে গেছে। এখন ডিরেক্টর অফ ফিল্মস হয়ে গেছে। চিফ সেক্রেটারি হয়ে গেছে। এটাও চেঞ্জ হয়ে গেছে। 40% দিয়ে দিচ্ছে। স্টেট বোর্ড দেবে না।
আমার ট্যাবে অর্ডারটা রাখা।
Yes. What is your submission?
There is a direction according to
Come closer to the microphone. Adjust the microphone, madam.
according to your last order, Lordship, there is a direction to submit a report with regard to the gratuity amount in favor of the writ petitioner.
First, tell me whether you have got all the area pension.
Oh, Lordship.
And what about the gross retiring gratuity?
Lordship, we just got 6 lakh something and
Are you properly instructed?
take instruction, Lordship. The puro list is given.
Who is your leading counsel?
Advocate Sushmita Shahadat.
Where is she?
She is very sick, Lordship. She has not come to court today. Kindly direct them to give me a copy of the report, Lordship.
Yes. You are for the state.
I am for the respond number 1, 2, and 3.
Please, she is little bit handicapped today.
Yes, my lord,
I am for 4, 5, 6.
My lord, only one humble submission, my lord, I am making.
Sir, adjust the microphone.
Yes. Now, my lord, the respondent number 1, 2, and 3.
Had
My lord,
disbursed their amount.
no, my lord, the difficulty is this right now they have been transferred from their respective post. So, my lord, subject to correction with your lordship's approval, my lord, the names, the concerned persons, my lord,
She is
the
little bit
present
handicapped
incumbent.
today. I'm making it not today only.
No, my lord, kindly, my lord, why? My lord, not today, my lord, lordship, kindly take it up after vacation. In the meantime, my lord, there may be a direction. My lord, I understand my lord, junior friend is handicapped. Only there to implement the, my lord, the present incumbents as the contemners. And my lord, only thing yesterday, my client has received one communication from the concerned municipality that the applicant is entitled of a sum of rupees 10 lakhs.
Towards
My lord, towards
area pension or area
my lord, area
retiring
pension.
gratuity.
Area pension.
How much
So,
it
my
has
lord,
been? How much has been disbursed?
my lord, out of that, there is a request upon the state respondents to disburse rupees 4,06,000. That is 40%. Yesterday, I have received this communication. So, on
No,
that
on the
also,
last
I will
occasion, you have stated that the proportionate state
No,
share
my lord,
towards
that's
area
why-
pension has been credited.
no, my lord,
Remaining
that's why
60% has been paid by us. Municipality has paid. 60% they have paid.
So, my lord,
That is your report.
yes. My lord, this is the communication, lordship may have a kind look.
But I am having the same copy. তুমি 7-5টা দিয়েছো 7-5-6টা দিয়েছো
7-5 তো দিলাম হ্যাঁ
Well, that 7th May's letter, my lord, in the first 3 lines records my disbursal.
No, Mr. Basu, on the last occasion you have stated,
No.
kindly come to paragraph 4. It is submitted by
But
Mr.
that-
Basu.
Yes, yes, my lord, I
Some
don't
advocate-
deny, but that
He
was
has instruction that the
lordship
proportionate
has been
state share towards area pension has already been
no,
credited.
my
into
lord,
the
that was my verbal instruction. That's why your lordship has been pleased to grant me liberty to come back with an affidavit. This is the present position. Your lordships, my lord, kindly cease.
So you have not disbursed.
No, my lord, that amount, my lord, I have to take instruction. This
What are you making? What submission you are making,
No,
Mr.
my lord, on
Basu?
the last occasion, my lord, there was a, my lord, there is some communication gap, my lord, I admit. Lordship, kindly allow me to come back on 12th of June. In the meantime, the present incumbents, my lord, they may be implemented as a party, I will come back. Regarding payment of 4,06,000, what has been indicated by the municipality, I will come back with specific instructions.
Same. আমার
Ashun,
ফার্স্ট 3টে লাইনে লেখা আছে
at the time of
will kindly review this. This is the one copy. What we have done is we have written to the director of local body. We have already issued that part, so far as the retirement benefit is concerned. So far as the gratuity is concerned, we have received 7,30,000. Currently, the situation of municipality is not so that we are in a position to pay. We have written to the government. Because not at the end of the day, all the finances what we have from the government. We will kindly peruse this letter. We have written to the director of local bodies, who is our
File it.
as a report in the picture. On the next picture, file this.
No, there is a direction to file it today.
Report is not there.
Then I shall issue rule.
Will kindly not.
No.
Will kindly not issue rules. We'll do it tomorrow. By tomorrow, we will serve a copy of the.
No, why not today, sir? I've called for a report.
We have the documents.
Sir, I don't want. I don't want to hear you. What I want that I want the compliance of the order. What is the report?
Kindly appreciate. We have already so far our bona fide is concerned. We have paid 60% already. We do not want to withhold any money which is not ours, which is theirs. But we are not in.
You have been directed to submit a report with regard to the disbursement of gratuity. Where is that report?
We have written this, we finalized this, and we could write this only on the 13th of.
So where is the predicament in submitting a report?
We have written it on 13th of November. Will grant us 2 days time, we'll file it. We'll file it. It is only on 13th May we could finalize and pay and send it. That's why there is a date.
With regard to the gross retiring gratuity,
indicate my inability. It's a contempt application. Even the alleged contemptors who are holding their respective posts, today they are not a party to the proceeding.
Very good.
Well, the chief secretary is not a party to
It
the
will go, sir.
proceeding.
It will go, sir. I've not issued any rule against him.
Well, I understand, but chief secretary is not a party to the proceeding even.
Sir, I will recall the order. You make payment right now. It's a contempt proceeding. You are. This court is fair
My lord,
enough that it has not
Then
issued a
lordship,
rule.
kindly, if your lordship so pleases, lordship, kindly fix this matter at 2 p.m. I will bring the judgment of the Honorable Supreme Court that an order, if something prima facie cannot be implemented, that is not implemented in a contempt. Because my lord, that
Basu,
was, my lord, I
last
know.
occasion you have submitted that it has
Yes.
been disbursed.
Yes.
A report, a
My lord,
contrary
that is
report
in
has come.
respect. No, my lord, that is
In
in
that
respect
event,
of
it is a
area
fit
pension.
case for issuing a rule.
My lord, I admit that.
If you want, I can issue a rule right now.
My lord, that is in respect of area pension.
Sir, don't make it. Don't make any excess. On the last occasion, rightly or wrongly, the court has been misled.
My lord.
Court has been misled.
But my lord,
You have the court has on your submission. You have on your court has recorded that you have
My lord,
disbursed
I don't
40%
deny,
of the
but
sale.
that is in
But
respect of area
report
pension
comes.
only.
Why a false? Why a contrary instruction has been
That
given?
is not in respect of subject to your lordship's approval on respect of gratuity. Subject to your lordship's approval.
I will not change my order.
My
For the petitioner, my lord. Though it is
All paginations are complete.
My lord, only one was missing. That is next item, my lord. This was in order, my lord. My lord, though it is the first time, my lord, my learned senior friend, Mr. Ghosh, appeared on behalf of the alleged contemptor. I think, my lord, we need not go into details because in similarly situated persons, he has been disbursed pensionary benefits in view of the order of the court.
Give me a second.
Yes, and issue has been settled up to Supreme Court. Well, kindly see your lordship's order, my lord. There is no dispute about the entitlement of the petitioner, my lord.
This shall pass it is in order.
Your lordship,
Yes.
Your lordship, no.
No, my lord, your lordship's pass to order for revisiting of the issue. And my lord, they never revisited because on similar issue, division bench passed the order directing them to disburse the pensionary benefits. Against that order, they preferred SLP. And my lord, SLP
is going to consider the grant of due pensionary benefit after taking note of the past services as casual other. So where is the compliance?
And my lord, kindly see, this is the order of the division.
I have not seen the petition, therefore I could not take it because it is the first time in the list where you lordship, my lord. What I am submitting, my lord, let him submit the submit the copies to the person concerned, the person responsible. In addition to that, a copy be given to me, my lord, so that I can take all instructions.
While he appeared without any notice, so my lord, the issue has been settled. Kindly see the division bench order of this honorable court. Only on the direction
the petition.
next আরেকটা আছে তো
একই order তো।
Same order.
7 and 8 the same order.
Same similar order it is.
This is another incumbent, my lord. And my lord, your lordship passed similar order like the.
Then same order, same order.
But may I take back the order of the division bench?
Yes, sir.
ওটা একটু দেবেন।
My lord, I am for the respondent in this matter.
For the petition.
This matter. Well, I'm for respondent number 5.
Private respondent.
Private respondent.
Private respondent.
5K.
You are for respondent, you are
private respondent, my lord.
respondent means state.
No. This is not the chilling plant.
Kishan Milk.
You are appearing for whom?
I am for the state, my lord.
State.
State, my lord.
State means 1 to 4.
1 to 4.
You are for respondent number 5.
My lord.
Affidavit of service has been filed already.
Already they have filed the opposition. The state is the already the state has filed it.
I have filed my report. He has filed the exception, my lord. Land was taken over, my lord, for the land. Kishan milk producer was the cooperative, na? 5 number. For whom the land was taken over and handed over to them.
Yes, place your case.
My lord, this is the second round of litigation, my lord.
Hmm.
My lord, what has happened, my lord? My lord, 2.2 acres of land belong to the petitioners. 2.22 acres of land in Mauja Rui Pukur, my lord. My lord, during acquisition, my lord, out of 2.22, 2.17 land was acquired, and my lord, compensation was paid, my lord. My lord, compensation paid, my lord, I have already annexed, my lord, at page 24, 25. My lord, then we filed an application under section.
Total land was 2.22.
2 acres, my lord.
Total land 2.22. Acquired.
Or acquired for respondent number 5.
Acquired. How much?
2.17, my lord.
2.17. So 0.5 acre left.
My lord, that is my case, 0.5 acres.
Yes. What is your contention?
My lord, we received compensation in respect of 2.17. My lord, we have annexed on page 25, 26. But on page 27, lordship, my lord, this is an order passed by the district judge at Noida.
Page number?
27. Read petition.
This is a land acquisition case.
Land acquisition case.
Huh.
My lord,
Acquisition and negotiation.
acquisition and negotiation. Under the old act, my lord.
Huh.
My lord, this is the order under section 18, my lord. But why I am placing this order? My lord, from this order, it will be reflected that only 2.17 land was acquired, my lord. My lord, on the first page, my lord, second paragraph, my lord, may I read for your lordship? These 4 LA cases were started for determination of fair and equitable. My lord, this para is not so important, my lord. My lord, where it will be, my lord. My lord, next page, my lord. Sir, page 28. Next. My lord. The collector Nodia for the project of Krishnanagar milk supply scheme. Well, that is the respondent number 5. Time to time, 2.17 acres out of 2.22 acres of land of plot number 2753 of Khotian number 2796 to 2800 of Mauja Luripuku, jail number 52, PS Kotwali, district Noida. And thereafter, possession was taken on such and such date. Notification under section 4 was published on 23rd November 78. Thereafter, award under section 7 was issued on 8 February 83. Malad, from here, Malad, I am demonstrating that 2.17 acres were acquired, Malad. Malad, come to page, Malad, then there, this portion of the order, Malad, deals with the valuation, or Malad, I am skipping all those. Malad, at page 32, my lord, internal page 6, page 32. Malad, third line. So, keeping in mind the valuation indicated in the sale deed produced, and also keeping in the mind of the location of the acquired land and its area 1.7 acres at a stage, and also considering the fact that it is located in such place which is very close to railway station and municipal area, I hold and conclude the market value of the land should be fixed at 60,000 per acre. So the market value of the land is 2.17 acres of land is such and such, my lord.
But from this order, my lord, I have tried to demonstrate that 2.17 acres of land was acquired, my lord.
Very good.
My lord,
Then-
thereafter, my lord, page 34, my lord, we made an representation before the ADM LA, Nodia, my lord, for return of the 5 decimal of land, 0.5 decimal of land. 5 decimal, 0.5 acre and 5 decimal of land, my lord. Page 34, my lord. My lord,
Application for return of 2.17 of acquired land and for demarcation of
that time
unacquired.
we have also prayed, that was our, that time also the case was that
So you prayed for demarcation of unacquired 0.5.
also, my lord. There
So
was
what is your case? They are using this.
well, first time that they are now still now they are not using the rest portion of the land, but we are there was twofold prayer in the earlier it present to return the
Please, now what happened?
now we have given those not praise that prayer manner. We are only praying that 5 decimal of land should be demarcated and returned back to me, my lord. That is the only case left now, my lord. Page 37, my lord, we made another representation. Page 37 before the ADM.
For demarcation of the unacquired 0.5 decimal.
5 decimal, man. And my lord, in the left hand side, there was
According to you, they are using that 0.5 decimal of land without making any acquisition process.
they are not using they are using only small portion of the land. That is not my game. 5 decimal is also left back in. They are not using the entire land.
Then what is the writ petition about?
For demarcation and return of the 5 decimal of land.
So it is still with you.
No, still with them. They are not using, but with them, not with me.
It is with their possession.
With their possession, my lord. My lord, I will demonstrate, my lord, from the clear. My lord, that the ADM has made a note on the left hand side, demarcation of the land to page 37, sir. Demarcation of the land to trace out 5 decimal, my lord, left hand side on page 37. Presentation to ADM. হ্যাঁ ওটা ওনারই নোটটা তুমি পড়বে কেন? তো উনি আমাকে কপি ফরওয়ার্ড করে দিয়েছেন, আমি পেলাম কোত্থেকে? My lord, thereafter we filed a writ petition. My lord, kindly come to page 40, the order, my lord.
40. Yes.
My lord, after contested hearing, my lord, it is contended on behalf of the petitioner as well as the pro forma respondent that about 2.22 acres of land belonging to the petitioner and the pro forma respondent were requisite by the state respondent out of
কল্যাণ এই তো সব খোলা গো, এই তো মানে সব কি কিরম ভাবে সব সেলাই করে সব খোলা। হুম কিভাবে কাজ করবো দেখি।
অফিসিয়াল সেক্রেটারি একটু ফেসে যাবে, তুমিও ফাঁসবে ওরাও ফাঁসবে।
Why have not speech it properly? Is everything open?
Matter has been taken up for hearing 7 to 8 times, my lord.
দেখা করে খুলে গেছে সবই, তো হারিয়ে গেলে মহা মুশকিল হবে, খুঁজেই পাবো না কিছু। লাগিয়ে দেওয়ার ব্যবস্থা করো। ট্যাগ আছে? লাগিয়ে দাও, লাগিয়ে দাও, লাগিয়ে দাও।
পরে
Yes.
Page 40.
Hmm.
It is contended on behalf of the petitioner as well as pro forma respondent
that about 2.2 acres of land belonging to the petitioner and the proforma respondent was requisite by the state respondent, out of which land measuring about 2.17 acres were actually acquired. The remaining 0.5 acres of land has not been acquired. The petitioner claims return of the said land after demarcation of the same. Malad, it is submitted, very important, Malad. It is submitted on behalf of the state respondent that the said quantum of land may be considered for return after the plot is demarcated, Malad. In view of the same, the writ petition is disposed of directing the second respondent to take necessary steps for demarcation of the plot in question in presence of the petitioner and the proforma respondent or their authorized representative within 3 months from date. Upon asserting the 0.5 acres of land belonging to the petitioner, which has not been acquired, the authority should consider return of the said portion of the land to the petitioner within a month thereafter. Malad, it was been undertaken by us that we will not pay for any compensation because
Then what happened, sir?
Malad, they thereafter they given notice. Malad,
Demarcation done.
Malad, demarcation. Malad, field note. Malad, page 43. Malad, last portion, second last paragraph. Malad.
Yes.
But as in ground reality, we cannot be able to demarcate it more than 1.8.
No, place the entire paper.
As per order of the Honorable High Court, Calcutta, in case number WPA 2499/2022, I see Dipankar Saha, SRO 2, DL.
Second paragraph. After extracting
the area, it is found that only 1.83 to 1.85 acres under RS plot number 2753 is under the possession of Kisan Milk Producer Cooperative Krishnanagar. That is the respondent number 5, madam.
Yes.
But as per order, 2.1 acre of land was acquired out of 2.22 acres of land.
Yes.
They are admitting, madam. But as in ground reality, we cannot able to demarcate more than 1.83 to 1.85 acres of land on RS 2753 of Mouja Ruipuku, jail number 52. Therefore, 2.22 minus 2.17, 0.5 acres of land on the said plot cannot be demarcated. A next date can be fixed, my lord. We give an objection, my lord, that we record our no physical measurement has been done as per RS area map. We give objection on the spot, my lord. My lord, then what happened, my lord? Without going for further demarcation, my lord, they passed the impugned order, my lord, at page 45.
Yes.
From the operating precedent, last paragraph on page 45. I'm reading the last paragraph. On careful observation of the documents, it appears that 2.22 acres of land in plot 2 number 2753 of Mouja Ruipukur, jail number 552 has been acquired vide LA case number 25R of 7778. Now they are contradicting their own statement. They are telling that 2.22 acres were acquired. And that has been notified in Calcutta Gazette vide notification number such and such dated 27 May 1978 under section 4 of the West
No. On careful observation of the document, it appears that 2.22 acres of land has been acquired. By DLA, it also have a compensation of 2.5 acres have already been paid to the awardees, including such and such. As such, it is clear that the statement made by that only 2.17 acre instead of 2.22 acre of land has been is not true. So they, according to them, entire land has been acquired.
Yes. Now they are telling. After so long, I have seen the district judge order. I have seen the award. I have seen the.
There is no scope to make further demarcation and return the land to the petitioner.
They admit they could not find the entire land, and after that they didn't take any steps for demarcation and came out with a different finding. They have admitted that they will pay, they will return the land after demarcation in the earlier petition.
Very good. In their what they have stated in their report?
They have told that they have acquired 2.
Have they annexed any notification?
Yes, I have annexed
notification.
I have got. I have already submitted my report.
There is also dispensation.
What is your report, sir?
Junior friend has, my learned junior friend has
Have you completed, sir?
I read it out.
Where is your report?
My lord, I have already submitted.
Give me a second.
Your lordship got it.
The exception, yes, report.
Report. My lord, before that, my lord, I trouble your lordship to come to page 45, annexure P19.
Page?
Of the writ petition, page 45, annexure P9,
yes,
which has been passed in terms of the order and passed in the writ petition number 2499. Lord, it has to be read into its entirety.
Yes, sir.
Lord, seen the solemn order from the top I am reading, Lord. Seen the solemn order dated 24th June 2022, passed by the Honorable Justice Shubhra Ghosh in connection with WP number 2499 of the 2000 Guru Prasad Chattopadhyay versus State. This is perhaps second round of litigation. To comply, the order of the Honorable Court, notice be issued to the writ petitioner and the other interested party fixing a date of hearing dated such and such AM. The next order, Lord, passed on. This has not been challenged in the writ petition. Their challenge is only that they want back 0.55 which has been not demarcated. But this is not under challenge. That should have been under challenge.
Which one?
This particular impugned order, which has been passed in terms of the order of justice.
My first prayer is to quash that order.
Your lordship.
I am interrupting. My first prayer is to quash that order.
Learned advocate.
Which order according to you ought to have been challenged?
Not this order, but his main prayer, not the primordial
That is
prayer.
my first prayer.
Primordial prayer. Primordial
Take your
prayer.
seat, sir.
Not primordial prayer.
One is senior is submitting contrary.
No, please take your seat.
Primordial prayer. Quash that order. This B, my lord. I am on B.
Well, kindly see
I am,
the A.
this is primordial prayer.
Challenge the order.
Primordial prayer is B. A writ in the nature of writs in the nature of mandamus issued thereby directing the respondent authorities to their main and agent.
No, which order ought to have been challenged according to you?
This has been challenged, but this has not been entirety. It has to be.
Please allow me.
Let me read out. Page 45. On behalf of Guru Prasad Chattopadhyay, the writ petition heard him in length, perused all documents submitted by LS section Nodia and the learned advocate present on behalf of the Guru Prasad Chattopadhyay, also perused the field inquiry report. Learned advocate orally submitted that 2.17 acre of land in plot number 2753 of Moja, Ruipukur, jail number such and such was acquired and compensation was paid for the said quantum of land. Next paragraph. On careful observation of the document, it appears that 2.22 acre of land in plot number 2753 of Moja, Ruipukur, jail number 52 has been acquired by the case number such and such, and that had been notified in Kolkata Gazette. That will come, that I have annexed in my report. Under section such and such, under section 4 of the West Bengal Land Liquidation and Acquisition Act 1948. It also appears that compensation of such 2.22 acre of land has already been paid to the awardees, including Guru Prasad Chattopadhyay and others. As such, it is clear that the statement made by the writ petition that only 2.17 acre of land instead of 2.22 acre of land in plot number 2753 of Moja, Ruipukur, jail number has been acquired by the state authority is not true. Necessary documents are shown and shared with the learned advocate present on behalf of Guru Prasad Chattopadhyay, who is the present petitioner also. As such, having regard to the facts and circumstances, it is concluded that there is no scope of further demarcation to return 0.05 acre of land to the writ petitioner, as the writ petitioner and others received award money for entire 2.22 acres of land, plot number 2753 of Moja, such and such. So compensation has been already paid for the entire 2.22 acre land. Now, Lord, I will come back to the report. Exception ta bar kor. Subruto. Unthe dara. Exception ta. Lord, may I read it out? Your Lordship kindly come to paragraph 3, page 2. I looked at that. Help God. Lord, may I read it out? Paragraph 3. That the government of West Bengal, for acquisition of land to set up a milk collection center, that is chilling plant. In the early 70s, not I have also seen at that time, the chilling plant used to be established. Chilling plant of Kishan Milk at Krishnagar in Noida. Perhaps they are the respondent number 5. Perhaps. Noida issued a notification being 8622 LA within bracket Roman 2 IG-2 of 78 dated 27th May 1978 under section 3 of the West Bengal Land Requisition and Acquisition Act 1948 duly published in Calcutta Gazette on 23 November 1978 in respect of RS plot number 2753 with Moja Ruipukot, jail number 52, police station Kotwali, district Noida, measuring an area of 2.22 acre, which has been requisitioned under section 3 of by the collector of Noida. Copy of the notification R1. Now, my lord, your lordship, kindly come to R1 at page 6. Now, there is a typographical error. That is 8822. It has not been corrected. That should have been 8622.
Which one?
On the top note, page 6, true copy of the notification. Your lordship got it. Nodia number 8822. That should have been 86. It is a typographical error. Others are remaining same. That is an others are remaining.
Okay.
Others are remaining same. Whereas 3.407456 hectares, that is 8.42 acres, more of land situated far or near the village of Ruipukut, described below, have been requisitioned under subsection 1 of section 3 of the West Bengal Land Requisition and Acquisition Act 1948 by the person authorized under notice 3(1)(a) of the Act for the public purpose, maintaining supplies and services of essential to the community, mainly for setting up of a dairy factory under the Krishnagar milk supply scheme. Now, therefore, notice is hereby given that in pursuance of section 4 of the said Act, the government acquires such land being required for the public purpose as aforesaid. Notice is given under the provision of subsection 1A of section 4 of the West Bengal Land Requisition and Acquisition Act 1948, West Bengal Act such and such, and to all whom it may concern. A plan of such and such. Now, description of the land, your lordship kindly come to the penultimate paragraph. Plot number, your lordship kindly see the disputed question, disputed plot is 2753 and 2754. 2.22 on the top, not done plot. Your lordship got it. Plot number 2753 specification, specific portion of the land, not done, area 2.22.
This is the type copy. What is the original?
The original is the not the before that page, the page 5.
Where from will get that?
Page 5 of my report.
No, that measurement, where from will get that?
Lord, it is not legible, Lord. This is not a legible copy. That's why I have given a typed copy, Lord. The particular portion. Page 5, your lordship kindly see. This is not legible copy. Lordship got it.
Yes,
that is not the legible copy. That's why I have given the true copy. That is the typed copy.
Oh, this here, yeah.
Your lordship got it.
2.22, yes.
Your lordship got it. Now, further, may I read it out?
Yes.
Now, my lord, I am now coming to paragraph number 4. For the said purpose, LA case number 25R of 77 was initiated by the district collector Noida. Paragraph number 5. The possession of the said plot of land was taken and delivered to the requiring body. That the Kishan. That the ki naam na jana tha? Krishnagar Mill Supply Scheme. That is response number 5. এইটুকুনি assist করবি তো নাকি রে বাবা? It also got it. That is R2.
Page?
R2.
Page 7.
Page 7, madam. Page 8 the typed copy. Page 8 is the typed copy, my lord. Page 8.
Yes.
Seen the material note of the DA and services return, all requisition order have been served. Okay, except form serial number 7 to 11. Official receiver Bijoy Kumar Bhattacharya is dead. PS has reported that the present receiver of the estate, Shri Ram Prasad Chatterjee and 4 others is Shri Harendra Prasad Bhattacharya, Advocate Krishnagod. As such, it has become necessary to serve with the present receiver, Shri Bhattacharya. The requisition order may please be signed by, and if no objection, ADM has kindly signed the requisition order to be.
So according to you, from the notification, it would reveal that the entire land was.
Entire land has been and compensation has been paid.
So there was no question of
No
return.
question of return.
Very good. Take down.
And compensation has been paid.
My
That
lord,
is there.
They have filed the notification.
my lord, they have filed the notification, my lord, from the order of the district judge and from their own admission, it has reflected 2.17
No,
acres
the
of land.
notification is
My
there.
lord, they have annexed 1983's compensation as.
No, they have annexed the notification. How can you challenge this notification?
My lord, let
They have
them know
annexed the
that-
notification,
that-
supported by affidavit.
Oh, that 5 decimal land, they have paid the compensation. Only that person, my lord.
Ashut. What have you got to say? এই তো উকিল শুনতেই পাচ্ছেন না।
নেই আছে কিনা কে জানে আছে লাইনে আছে
You are appearing on behalf of the respondent number.
And my lord, my specific case was the 2.2.
My lord, I'm appealing for respondent number 5. Kishan
right.
Milk Bikash Milk Produce Cooperative. The private respondent number 5.
What have you got to say?
My lord, the entire land was sent to us. It was allotted to us by the land department.
What's your good name?
Amitabo Mitro.
Take down.
My lord, my specific case was that 2.22
You
was.
are Mr. Samanto.
My lord, 2.22 was requisite, 2.17 was
Very
acquired, my lord.
This court has heard learned advocate for the writ petitioner, comma, learned advocate for the respondent numbers 1 to 4.
Ashim Ganguly AGP with Subrata Das.
Sorry?
I am Mr. Ashim Ganguly AGP with Mr. Subrata Das.
Yes. This court learned advocate for the respondent number 1 to 4 and learned advocate for the respondent number 5 who appears before this court in virtual mode. Stop para. By filing the instant writ petition, the writ petitioner has prayed for issuance of appropriate writ of writs against the respondent authorities for quashing of the order dated 6/12/2022 as passed by the respondent number 2, with a further prayer for issuance of appropriate writ of writs for immediate demarcation of 0.5 acres of land out of 2.22 acres of land in RS plot number 2753 in Mouja, Lui Pukur, jail number 52 PS Kotwali, district Nadia. Stop para. It is pertinent to mention herein that while passing the order under challenge dated 6/12/2022, the respondent number নাম্বারটা বলবে না ডিএমটিটা বলবে একটু আগে 3 respondent number 2 authority found
May I take leave?
yes sir found no merit
Hey,
in the representation of the writ petitioner for returning for demarcation and returning of 0.05 acres of land in the aforementioned Moja, and thus declined and thus came to a finding and thus declined to consider the representation of the writ petitioner favorably. Stop para. At the time of hearing, learned advocate for the writ petitioner at the very outset draws attention of this court to page number 27 to 33 of the instant writ petition, being a copy of the judgment and order dated 30th April 1994 as passed by learned district judge Nodia in MISC LA case number 2486, 2586, 2686 and 2786. It is submitted that from the said judgment and order, it would reveal that that under the process of requisition and acquisition as initiated by the then land collector under the provisions of West Bengal Land within bracket Requisition and Acquisition Act 1948, hereinafter referred to as the said Act of 1988, 2.17 acre of land out of 2.22 acre of land in the aforementioned plot was acquired and possession thereof was taken by the respondent authorities, which was subsequently handed over to the respondent number 5 being the requiring body.
My lord, one indulges, my lord.
Stop. At this stage, learned advocate for the writ petitioner again draws attention of this court to page number 37 of the instant writ petition, being a copy of the representation of the writ petitioner dated 18/11/2020, addressed to the Additional District Magistrate General Nodia, whereby and whereunder the writ petitioner has made a prayer for demarcation of his unacquired 0.05 acre of land in the aforementioned plot of land.
My lord, one indulges, my lord. My lord, kindly say page 30, my lord. The notification date also is mismatching. My lord, kindly see
Stop para.
page 30, my lord. Section 4 notice, my
It
lord.
is submitted that since such representation was not considered favorably, the writ petitioner approaches this court by filing WPA 2499 of 2022, which came to be disposed of by a coordinate bench on 24/6/2022, wherein the said coordinate bench, while disposing the said writ petition, directed the respondent authorities to ascertain to take appropriate steps for demarcation of the plot in question, and thereafter to return and thereafter to consider the aspect of returning 0.05 acres of land belonging to the writ petitioner. Stop. It is submitted that pursuant to such judgment and order dated 24/6/2022, the respondent number 2 has passed the order under challenge. Stop. It is submitted on behalf of the read petitioner that the respondent number 2, while passing the said order, has completely misguided himself in as much as he has failed to visualize that in the judgment of the aforementioned Miss LA cases, it would reveal that in the said plot of land, only 2.17 acre of land was acquired out of 2.22 acre of land as per the provisions of the said Act of 1948. It is just submitted that in view of such, it is just submitted that the order dated 6/12/2022 as passed by the respondent number 2 authority is based on extraneous substance which vitiates the decision making process, for which judicial review is warranted. Per contra, Mr. Ganguly, learned additional government pleader, appearing on behalf of the respondent state and its functionaries, at the very outset draws attention of this court to the report in the form of affidavit as submitted by the respondent number 2, 3, and 4. It is submitted by Mr. Ganguly that from paragraph number, that on perusal of paragraph number 3 and 5 of the said report, vis-a-vis page number, now it is submitted by Mr. Ganguly that on conjoint perusal of the said report, including its annexures, it would reveal that by a notification dated 27th May 1978, a notice was issued under section 4 of the said Act of 1948 regarding acquisition of plot number 2753 to the extent of 2.22 acres of land. To the extent of 2.22 acres of land. And after completion of process of acquisition, the possession of the said 2.22 acre of land was handed over to the requiring body, who is the respondent number 5 here. It is just submitted that by no stretch of imagination it can be said that in the said plot of land, by the said notification dated 27/5/1978, 2.17 acre of land out of 2.22 acre of land was acquired. It is further submitted by Mr. Ganguly that the order which is under challenge before this court is based on the said notification, and therefore there is hardly any scope to interfere with the said order. Stop para. On careful consideration of the entire materials as placed before this court, and after hearing the learned advocates for the contending parties, it appears to this court that that on behalf of the respondent state and its functionaries, a copy of the notification dated 27/5/1978 has been placed, wherefrom it reveals that under the provisions of the said Act of 1948, a notice under section 4 within bracket 1A of the said Act of 1948 was issued for acquisition of 2.22 acres of land in plot number 2753 in the aforementioned Mauja. Stop. In view of such, this court has got no hesitation to hold that the sufficient materials have been placed before this court. Hesitation to hold that sufficient materials has been placed before this court, that in the aforementioned plot, the entire 2.22 acres of land has been acquired in terms of the provisions of the said Act of 1948, and compensation for such acquisition has already been disbursed to the recorded owners. Stop para. In view of the discussion made here above,
My lord,
this court thus finds no reason
my lord, on the basis of a illegible
to,
notification.
to interfere with the finding of the learned district magistrate. Stop. With the finding of the learned district magistrate dated 6/12/2022.
My lord,
Stop para. This court thus finds no merit in the instant writ petition, and the instant writ petition is thus dismissed.
my lord, kindly
There shall
record one
be-
submission, my lord.
There shall be no orders to cost.
My lord, kindly record one submission, my lord. I am disputing the notification also. My lord, kindly see the district judge order and what the learned state advocate submitted, my lord. My lord, kindly see, my lord.
As my judicial order, you know what to do.
My lord, kindly record my submission. It is contradictory with the order.
Very good.
My lord, notification date is also different, my lord.
Let me come back. Yes, call the next matter.
May it please your lordship. My lord, I appear with the petition in this matter. On the last occasion, your lordship, there was a liberty given to us, your lordship, to file a supplementary affidavit, your lordship. My lord, I have appended certain documents which are German for the adjudication of this matter. Your lordship kindly takes this on record, my lord.
My lord, I am appearing on behalf of the state, my lord, led by Mohammed Ghali.
My lord, if I may indicate what the writ petition is.
Give me a second. What is your case?
My lord, my writ petition is against the illegal, my lord, occupation and acquisition of 1.19 acres of land in Paschim Medinipur, my lord, Mouza Habra Dihi. Now, my lord, this acquisition has been made in respect of Kongshaboti Canal Division, my lord, excavation of canal. My lord, extension of the canal works was my lord, the proposed proposal that was given to the my lord, proposal was given to the petitioners, my lord. Previously, my lord, there was 0.60 acres of land regarding same plot number, my lord, that was acquired by the respondents. Appropriate compensation, my lord, was provided to the petitioners. Subsequently, my lord, 1.19 acres of land that was also acquired by the respondents, my lord. That was no compensation was, my lord, given to the petitioners, as well as, my lord, it was acquired without due process of law. My lord, this is in regard, my lord, we have also, my lord, these facts, certain facts were, my lord, missed out from the writ petition, my lord. We have.
Have you served the supplementary copy of affidavit?
Yes.
Copy to me, pai.
Supplementary.
So place the documents to substantiate.
My lord, I have not filed.
I have not received any documents. my lord.
It has been served yesterday, my lord. So they may not have given sufficient time. But it has been served. I am showing on also the service, my lord.
So it was served yesterday.
Yes, yes. They have not given. They may be given.
Where is Mr. Ghalib?
He's engaged in another court, my lord. He's on lake, my lord.
So I'm making it not today.
No, my lord,
Ashwin.
make it short Passover.
Passover is not possible. The supplementary affidavit has filed today on behalf of the writ petitioners.
What's Jana? I am praying only not.
Liquidation হলো আমি Passover চাইলাম কোর্ট
Not today.
আদার সাইড যে রিপোর্ট দিয়েছে আমি তো কপি পাইনি তা কোর্ট
You are always asking for adjournment. Not
No, no, see, they are still there. I can take it up.
Your lordship, kindly. These journalists.
Passover
Why are you asking for power? You will not start your case.
Call item number 10. Order কেটে দাও. Recall that order.
Item number 11.
Item number 11 not today. Mr. Ghalib is here. Item number 10 টা দাও. Yes, place your case.
My lord, in the year 1965, my lord, for the purpose of Kongshaboti project, my lord, a land was acquired by the state government. My lord, on the said acquisition, my lord, subsequently was challenged in the year 19 72, 75 in title suit has been filed. My lord, thereafter, my lord, a writ petition has been filed, my lord, in the year 2000, my lord. On the first writ petition, my lord, court was directed to consider the representation, my lord. On the basis of the representation, my lord, I have filed a supplementary affidavit, my lord. Representation was annexed in the supplementary affidavit, my lord. Kindly come in page from 10, my lord.
Page 10.
From 8, my lord, from annexure P3, my lord, page number 5. This is the order, my lord. On the basis, this is the order passed in connection of the writ petition in 2000, my lord. My lord, on the basis of.
Give me a second. Yes. Then what happens, sir?
My lord, on the next page, my lord, in page number 9. In page number 9, my lord, this is the proceedings, my lord. Proceedings of the meeting where the ADM LA, my lord, in Paschim Midnapur, my lord. In the said proceedings, my lord.
Yes.
My lord, in page 10, my lord. This is the after. In page 10, my lord, after my lord, second paragraph, my lord.
Yes.
After detailed discussion, the following were resolved. Original proposal was for 1.19 acres of land, and the RB is in possession, requisition body, my lord. RB is in the possession of the same area, but finally possession was delivered to RB on 11th 1968, my lord. For the area 0.58 acre and plot number 61 and 0.2 acre in plot number 80, totaling 0.60 acre in Act, my lord, LA case number 9 of 1966-67, arising out of LAP case number such and such, my lord. My lord, as the proceedings was under LA Act, my lord, without invocation of section 17, evident from notification, the compensation must have been made before the delivery of possession of 0.60 of land as aforesaid, my lord. In RB, requisition body is requested to take action on the mutation of their land in BLRO department, my lord, Salboni, by submitting such and such, my lord. My lord, no record was available with RB showing the departmental transfer of the then vested land in favor of the, my lord, Kongshabati Canal Division for the requisition body, my lord. As the RB has no record of departmental transfer of vested land in their favor for the excess land, my lord, already occupied by them, and already occupied by the requisition body, my lord. And the scheme executed thereon, which is at present Rayati, the executive engineer, Kongshabati Division 4, is to submit a fresh proposal under Act 1 of the 1894 for acquisition of 0.59 acres of land to settle the matter, my lord. My lord, thing is this, my lord, till date nothing has been, my lord, proceeded with, my lord. Regarding 1.1 acres of land is under the possession of the, my lord, state authority, my lord. We made in the second limb of writ petition, my lord, we made
Give me a second, sir. So according to you, from this report, it would reveal that the acquisition process for 0.59 acre of land has not been started.
Nothing, my lord.
But still they are in possession the same.
But in the record of rights, my lord, it is in our favor, my lord. Well, we have made representation, my lord, in writ petition. It is annexed in, my lord, page 42, my lord. That has not been considered.
My lord, may I respectfully, my lord, assist you?
Page number 42.
Yeah, my lord. In the original writ petition, my lord. No, representation. It starts from, my lord, page 42, my lord. Our representation, my lord.
So Mr. Ghalib, let the BLRO make an field verification and submit a report
My lord,
to
may I,
the land acquisition collector.
my lord, respectfully, my lord, submit, my lord. My lord, the grievance of the petitioner is, my lord, the crux is, my lord, clearly stated in paragraph 2 that he is aggrieved at 1.19 acre of land comprising 2 plots.
You are referring paragraph number
2 of the writ petition.
2 of the writ petition. Yes.
This is what, my lord, he says. 2 plots are involved and the quantum of land is 1.17. It should be 1.19. My lord, it's a case of 1966 and 1964. Now, my lord, authority, my lord, is of the opinion that yes, these were acquired partly under Act 1 of 1894 and partly under Act 2 of 1948. Along with other plots of lands, total 1.83 was acquired. So, my lord, what, my lord, may I, my lord, respectfully suggest your lordship subject to lordship correction? Since my learned friend has preferred a representation, my lord, I am of the opinion this authority, since one set of instruction coming from an executive engineer, another set of instruction coming from a special land acquisition officer. So, my lord, may this, my lord, representation be directed to be considered by the DM, collector, so that he can come up with a reasoned order and thereafter, my lord, we can go for challenging that if he is agreed by the reasoned order. So, may this representation be sent, my lord, at page 42, which my learned senior friend has referred to your lordship at page 42 of the writ petition. May the DM be directed, my lord, to consider, since this has not been considered at
Who
all.
is the acquiring body? The special land acquisition collector?
Acquiring is in the name of collector always, a special land acquisition collector. Since your lordship is directing, so it should go to the collector, that is DM. Kindly direct the DM to pass a reasoned order on this particular, my lord, representation, to shorten the issue as of now, lordship.
The respondent number is not the respondent number 3.
No, DM is not, special land acquisition collector is the authority who initiates the proceeding of acquisition. But it is in the name of collector always, lordship knows that, DM.
District magistrate will consider.
Yes, he's the collector.
So let me do one thing. Let the respondent number 9 make a field verification. And he submit a report with the district magistrate and the district magistrate shall...
Lord, I am with the report of, my lord, this BLLRO, they will not be able to tell any story about the acquisition process. So the acquisition starts, my lord, from the special land acquisition collector. It's separate, lordship knows, it's a separate department of the district. Land acquisition department is separate. So special land acquisition collector is the authority who can, my lord, throw some light on this entire episode of land acquisition of the district. And that was the requiring body was irrigation. So irrigation should not be held up now. So acquiring body was this special land acquisition collector. But all the notifications are issued in the name of the collector. That is DM. My special land acquisition collector has given me a report. This report is on, my lord. If your lordships, my lord, allow me to, my lord, place this. They say, my lord, this was acquired. May I respectfully hand over a copy of this report, my lord, given to me by the special land acquisition collector. May I respectfully hand over, my lord. Kindly sees, my lord, he says the name of the project was this Kongshaboti Reserve project. LA case were two LA case, there were two LA cases opened. One was under Act 1 of 1894 of 1963-64. Another of Act 2 of 1948, 1967. Total quantum of acquired land comprising these two land acquisition cases were 1.83. Now, kindly sees, my lord, he says name of the RB, clear. In kindly sees date of handover position in clause 6, he says the lands were handed over to the RB on those 2 dates. Now, there are court cases involved over the issue. One writ petition they have referred to, my learned friend is referring to another writ petition. So there were 2 writ petitions already. The third writ petition, oh yes, they have referred to 2 writ petitions. One was 26191, and my learned friend has referred to another writ petition. Now kindly seize the concluding part of the report. After verifying available office records and the records supplied by the requiring body, it is clear that the ALA compensation was paid to the petitioners and the possession of the land was handed over to the requiring body. This is what he says, the special land acquisition collector.
Take down.
So, my lord, if this be the case, my lord,
হ্যাঁ wrong. $15. Who's for the state?
15, my lord, I beg to appear for the petition. State, I don't know, my lord, I have served. This is my affidavit of service.
দেখি দাও গো, কে আছেন? It is appearing for the first time. Is there any private respondent, sir?
No, no. The government officials, Union of India, because the acquisition, my lord, took place. Union of India, perhaps the respondent author.
Answering respondent is the Union of India.
Because, my lord, the acquisition took place in view of National Highway Act 1956. Under section 3.
National Highways Authority is the party.
Yes. Respondent number 2.
Respondent number?
1 and 2. My lord, my learned senior is there.
Actually, my lord, on behalf of the Mr. Ranjan Datta in appearance of the
Sorry?
Union of Ranjan Datta, appearance of the Union of India, my lord. My lord, he has not come today, my lord.
I cannot hear you.
He is asking adjournment for not.
I am praying for not today.
Because my writ petition is to that extent is that the respondent number 11 being the special land acquisition officer decided a compensation amount, which I put an objection is that this is not a, this is inadequate in view of the market value at that point of time. That representation till date, they are sitting tight over the matter, not decided till date. This is my writ petition to decide my objection with regard to the inadequate compensation. My representation. Because twice
We will appear on we normally appears on behalf of the state.
my lord,
I am
From
from the
Sarthak you can ascertain.
Yes, yes. Sarthak. From the Sarthak, my lord. Then let me come back to then, my lord, let me come back.
I have only
So the affidavit of service is filed today on
ঠিক আছে
Great.
I appear for the private respondents number 6 to 17, my lord.
It's for the state.
I beg to.
Well, I am appealing for the Chandanagar Municipal Corporation.
For the state respondent, Lord. I beg to appear on behalf of my lord petitioner, my lord. My lord, we have challenged one order.
Give me a second, sir.
Ocean, sir. এটা তো ভিটি তো
This is a land matter.
Because of my lord, the pond, they are claiming this is a pond, and it is up to the Chandanagar Municipal Corporation, my lord, since they are the appropriate authority.
It is a land matter or the municipality matter?
Municipality matter. It's a matter under the Inland Fisheries Act, to be exactly specific.
So if that be so, in that case, it is land matter. My lord, the ponds include, my lord, land includes pond.
What is the nature of the order? Show me.
The nature of the order is 40A, and the order, my lord, the ordering portion is 42 onwards. May I place it, my lord?
Yes, sir.
My lord, I'm just drawing
No,
notes.
what I intend to ascertain whether it is within my determination or not.
Absolutely, my lord.
That I intend.
My learned friend, my lord, on behalf of the private respondent, is of the opinion it is within the four corner of the Inland Fisheries Act 17A, lordship knows. My lord, if that be so, any pond, land includes pond, and that being the situation, and that it comes before this honorable court. My lord, one can choose.
Which order is under challenge?
My lord, challenge, my lord, 40A, my lord, order number 12, page 42, dated 6/6/2024.
40A?
40A starts from 40A. The inquiry. Lordship, kindly turn to page 42.
42.
42. Order sheet. I'm just placing it.
Yes.
Today is fixed for the order under section 17A of the West Bengal Inland Fisheries Act 1984 against the complaint of illegal filling of water body in Kumorpada, Jugipukur, Chandanagar, Mouja, Swanso, Chandanagar Municipal Corporation. A complaint was lodged by the Dhruvo Ruidas and others of Swanso, my lord, the ward number Swanso of Chandanagar Municipal Corporation, to the Secretary Government Department of Fisheries regarding illegal filling of pond. One Subhash Pal, Subroto Pal, Sukhen Pal, all sons of late Lokhinarayan Pal of Kumorpada, Jugipada Main Road, duplex party, possibly. The complaint was forwarded from the end of Deputy Secretary to the Government of West Bengal, Department of Fisheries, Aquaculture, Aquatic Resource, Fishing Harbour, by so and so number, along with the report of the Assistant Director Fisheries, Hooghly, and the report of Satellite Data Laboratory of Department Fisheries Mapping Project Unit, Commissioner Chandanagar Municipal Corporation being the competent authority, initiated the proceedings under section 17A of the West Bengal Inland Fisheries Act. My lord, I pause for a moment. The commissioner claiming to be the, my lord, the appropriate authority of Inland Fisheries Act without indicating as to how he became, my lord, the appropriate authority under the Inland Fisheries Act. Then, my lord, inquiry was done by this office. As per the inquiry report, the work of filling of the said plot of land was undertaken, but no prior permission from this corporation was taken before commencement of this work. All concerned were called for hearing and heard them. During hearing, complaint stated the respondent numbers 3, Subhash Pal, Subroto Pal, Sukhen Pal, and my lord, the owners of the said plot. The complainant disclosed that as per their knowledge, there was a physical existence, my lord, the knowledge of pond on that plot of land long ago. They complained that the said water body is being filled up illegally. They also submitted some photograph which reveals that some activity for filling up the said plot was taken. Officers appeared on behalf of the Department of Fisheries, produced relevant report. The what report? Pleader of the respondent pleaded that there was no existence of pond, and kindly turn to the next page 43. Submitted copy of ROR, record of right, in support of his contention. But report of Assistant Director of Fisheries reveals that though the said plot is recorded currently as VT, there is no existence of water at present, but the spot in instant cases shows certain all characteristic of a filled up water body, as the spot was infested with the aquatic weeds like colocasia species at the time of inspection. A report of Fisheries Mapping Project Unit also reveals that so-and-so area of the land within plot number so-and-so was a water body with the presence of hydrophytes and aquatic plant during the year 2010. The area of the water body decreased gradually over time, and up to November 2020, the said area was appearing as marshland. From the relevant report, the Assistant Director of Fisheries, Hooghly, and satellite image observation report of Fisheries Mapping Project Unit, it is evident that the said land in the instant case was water body, but gradually area of the water body was decreased. The residual portion was filled up illegally in contravention of the provision of 17A and subsequent act with the intention to use other than fisheries. Hence, the owner Subhash Pal, Subroto Pal, Suken Pal of the said plot are directed to restore such water area, including embankment, to its original condition at his own expenses within a period of so-and-so from the date of receipt of this order, failing which legal action will be initiated against the respondent authorities as per provision of section 17A West Bengal Inland Fisheries Act. Now, my lord, once again I am drawing lordship attention from page 42. My lord, here inquiry was done, paragraph 1st, 2nd, 3rd paragraph. The complaint was forwarded after 3-4 line with the report of Assistant Director of Fisheries Hooghly and the report of the Satellite Data Laboratory of Department Fisheries Mapping Project Unit. Well, we are yet to receive any copy of all this, my lord.
Where from I'm getting?
My lord, paragraph 3.
Yes.
After 3-4 line, they are heavily relied upon, my lord, the Satellite Data Laboratory report and mapping Fisheries Mapping Project Unit. Commissioner Chandanagar Municipal Corporation, being the competent authority, initiated proceeding under section 17A of the West Bengal Inland Fisheries Act. Our humble submission, my lord, subject to correction. My lord, since my right has been crystallized, it is recorded in the ROR, record of rights as VT, in the record maintained by the BL and LRO land reform. Lordship knows, my lord, there are some presumption as far as the record of the BL and LRO is concerned. My lord, this is a forward presumption. And here, my lord, they are relying upon all this document without supplying all this document to us. Inquiry made, my lord, never allowed us to take, my lord, the exception of that inquiry report. Then, lordship, inquiry was done by this office. My lord, no indication inquiry was done in presence of the all concerned parties. The work of filling up the said plot of land was undertaken, but no prior permission. My lord, the municipal authority is not the appropriate authority to give permission. It is the BL and LRO. Lordship knows, and under section 4C, my lord, the classification is required.
No, Inland Fisheries Act, the commissioner is the appropriate authority.
True. For filling up a pond, permission is required to be taken from the.
Got the book.
I bought the book. My lord, the
Give it to me.
4C of the Land Reform Act, my lord. I'm showing.
No, I want to see the
Inland
Fisheries
Fisheries
Act.
Act.
Yes.
I'm handing it over, my lord. Inland Fisheries Act. Oh. My lord, the commissioner is the appropriate authority as far as municipal corporation are concerned. No record has been, my lord, submitted to us, or my lord, they have indicated.
Give me a second. Give me a
we can
second.
take it out from the.
My
lord, the Fisheries Act, lordship, last part, my lord. Last two law, my lord, possibly one is, my lord, Inland Fisheries Act. Lordship got it? Or otherwise I can hand over my book.
Yes.
Lordship got it. Then, my lord, kindly see.
Give me a second, sir.
কোন কোন প্যারা দেখেছো বলো?
When there is a notification to that respect, my lord, may I hand over that notification. Where is the commissioner, municipal commissioner has been authorized as a.
Yes, I know that.
Yes.
Give the notification.
capable of being.
Yes.
Lord, I'm placing, let's see, paragraph 4 of the order, page 44. Inquiry was done by this office, and as per inquiry report, the work of filling up the said plot of land was undertaken, but no prior permission from this corporation was taken before the commencement of this work. Once again, I will repeat, my lord, so far, my lord, the filling up pond is concerned, only compensatory water body is required to be made, and my lord, the conversion is to be made in terms of section 4C. It is not the municipal authority who can discharge the duty of, my lord, granting permission. Then, my lord, all concerned are called for hearing and heard them. During hearing, the complainant stated that the respondent number so and so. Then, my lord, the complainant disclosed that the fact, as per their knowledge, there was physical existence of water body, of pond on the said plot of land long ago. He complained that the water body is being filled up illegally. Then, my lord, kindly come to my lord. Then I'm skipping. Officer appeared on behalf of the Department of Fisheries, produced relevant report. My lord, we are not part and parcel of that report. We were, my lord, invited to be present in the spot and, my lord, to take part while preparing the report. My lord. Then, my lord, turn to page 43. But report of the Assistant Director of Fisheries reveals that though the said plot is recorded currently as VT, there was no existence of water at present, but the spot in the instant case shows all characteristic of a filled up water body, as the spot was infested with the aquatic weeds, swans. So our humble submission, my lord, while examining the other record maintained by the BL and LRO, I can also show page 26 onwards that it is recorded as VT for a considerable period of time. Now, my lord, on the basis of his, my lord, cursory look, he come to the conclusion that some aquatic weeds are there, as a result of which it is to be.
Why are you saying with a cursory look?
Kindly see.
All are outcome of a scientific investigation.
If the scientific, lordship, kindly see, if the scientific investigation is
Record of right raises a presumption, but it's a rebuttable presumption.
Debatable presumption.
Huh.
Our humble submission, my lord, they have done this particular inspection inquiry was taken into consideration. Whether, my lord, they have allowed us to take part, one thing. The other thing, they are relying upon certain document, whether they have supplied all those documents to us to counter it. We have a right, and that right has been crystallized in the record of the BL and LRO. Subject to correction, my lord, I know, my lord, it's a rebuttable presumption. if they intend to revert it in such a fashion, my lord, they should also allow us, my lord, to supply all those documents and to counter it and to say something. Here, my lord, on the spot, the instant cases shows the characteristic of a field of water. So while visiting the spot, they come to a conclusion it was a pond because there are existence infested with aquatic weeds. This is their subjective satisfaction. This cannot be done in this fashion, my lord. This is our humble submission before this report, my lord. Then, my lord, kindly come and water body from the 2010 onward. Then the next paragraph from the relevant report of the Assistant Director of Fisheries, Hooghly, satellite image observation. It is, my lord, the state is, my lord, the powerful. They have the all apparatus to do all these things. But at the same time, my lord, being a, my lord, it's not a property right, it's not a, my lord, the fundamental right, but still constitutional right. We are not entitled to have a copy of the satellite image observation report of the fisheries mapping project unit. It is evident that said plot of land in the instant case was the water body, but gradually area of the water body was decreased. The residual portion was filled
No,
up.
sir, what I'm on. So what is the scope? What is the scope for interfering with this finding in a judicial review?
Here only, my lord, because the particular, my lord, the pond must be capable of being, my lord, the pisciculture. That is the mandate of the law.
No, sir.
Showing, my
That is for the purpose of.
Lordship.
That is for the purpose of 17A subsection 1.
Lordship. I'm
No,
coming.
and we are governed under 17A section 10.
Lordship.
Subsection 10.
Lordship. Bar to conversion, Lordship, on subsection 10. My lord, they have not indicated this is.
You are talking about bar of conversion, that is talking about subsection 1 and subsection 2.
Lordship.
For which an objective satisfaction is required, that land is required for the purpose of pisciculture.
Here, my lord,
now come to subsection 10.
My lord, whether that
The
particular
competent
subsection.
authority by written notice require any person who by contravening the provision of subsection 1 puts an area such and such, fills up an area, divides in any area, so to restore as may be specified in such notice.
So, my lord, in the four corners of this.
In a judicial review, what is the scope of what is the scope of interference
I'm coming.
in a finding
Lordship.
which is based on scientific evidence?
No, well, scientific evidence cannot be unilateral, my lord. They have relied upon this report without furnishing a single scrap of paper to us. I am putting this question to myself.
Yes.
This is one aspect. The other aspect is in four corner of 2 pages order, my lord, they have indicated 17A. Is there any indication of 1710? 17A10, my lord, which this honorable court was kind enough to refer?
Caption does not matter.
No, but at the
must
same
go
time,
we must go by the content.
Then, my lord, we are relied upon a
We
judgment.
must go by the content,
My lord,
not the caption.
My lord, true, my lord. The section, if wrongly quoted also, then also that is not fatal. This is settled proposition.
Suppose
of
it
law.
has been an application under Order 6 Rule 17 CPC.
Lordship.
But from the facts and circumstances and the prayer, I find there is an application under Order 13 Rule and 2. I will go by the prayer, I go by the content on the prayer or go by the caption.
But at the same time, my lord, we know, my lord, quoting a wrong provision may not be the fatal. At
I
the
understand
same time,
your contention.
This
What
is
is your contention?
only one aspect, my lord, a reported judgment passed by the Honorable Justice Dipankar Datta as his lordship then was. I am just relying upon, then I will conclude my submission. My lord, kindly see, this is a reported judgment in 2010 for CHN, Calcutta 125.
Kindly,
Madam, I'm again, my lord. This
Yes,
is
madam.
2010 for 10
Yes.
4 CHN.
4 CHN.
125 Calcutta.
Yes.
Now, lordship, kindly come to my lord. I am drawing lordship attention.
Paragraph
first,
number?
Paragraph number 30, my lord, first.
30.
30.
No.
My lord, there could be no reason to doubt that wherever water area, including embankment or naturally and artificially depressed land holding as a faucet, and such water area, including embankment or naturally or artificially depressed land holding, have been used in section 17A, the expression as a faucet and such refer either to any other water body, including embankment measuring 5 cutters or 0.
Sir, I have gone through this judgment.
Lordship.
While taking similar such matter
Lordship.
in respect of a Kolkata Municipal Corporation.
Anuradha Shenmay.
I believe so.
I think Lordship
Because
was sitting with Honorable Justice Orijit Banerjee.
Yes.
Lordship, let us come back to with that particular judgment.
No, no.
A day
But
में
this
कल
is, this is with regard to subsection 1 and 2.
Yes.
Not in subsection 10. I know
But
that. this
10,
judgment.
Lordship, my lord, 10, my lord, they have not indicated 10. They have indicated 17A. And then, my lord, paragraph 30, paragraph
Sir,
30.
from this judge order,
Yes.
rightly or wrongly, it has been found that an order has been passed for restoration to maybe restored to its original condition at his own expenses.
True.
That is under subsection 10.
My lord, the 10 they did not mention. At the same
No,
time,
no,
my
this
lord,
judgment is in respect of 17(1)(a), subsection 1 and 2, not with respect of subsection 10.
here, my lord, they have referred 17A only. In the four corner of this order.
Very good, I understand. What
Yes,
is your contention, sir? You are appearing for?
I'm for the my lord, private respondents. Lord, just 3 paragraphs Lordship would firstly take of his writ petition. Paragraphs 5 and 6 and 7.
Give me a second. Paragraph number?
5, 6 and 7.
Yes.
My lord, this shows that the activity that they were doing.
Kindly place, sir.
Yes.
That was low land. Felt desirous to develop.
The petitioner states that the petitioner along with the other co-owners felt desirous to develop the said landed property by way of making small plots of the same and by way of selling the same to the intending purchasers. As the petitioner had no knowledge and or working experience in the field of developing and or promoting properties, so this is the difficulty. The petitioner with the other co-owners searched for experienced persons who could do necessary ground level work and bring prospective buyers. Accordingly, the petitioner approached the competent persons for the purposes of developing the property. Then, my lord, 7. The petitioner states that the land in question was a little lower in height in comparison with the level of the main approach road, metal road, as maintained by the local authority. As the same was a little lower in comparison to the approach road pathway leading to the said land, the petitioner was advised to initiate necessary leveling works upon the said land. But this is what they did. Now, my lord, kindly take 1710. 1710A2. Malad ignores the first part, fills up any, not forgets Malad water area. Naturally or artificially depressed land holding. This is exactly what the case is. Then Malad, my learned senior says he's not been provided a copy of the report. Kindly takes page 40 of his writ petition.
Yes, sir.
Turns over the page, Malad, the typed copy. That is the copy of the report. Kindly sees. At present, there is no existence of water in the above noted plot. Now the plot is infested aquatic weeds like Colocasia sp, which indicates the possibility of existence of water body. And my lord, one very important provision.
Very good. Listen to my order. Listen to my order.
My lord, kindly see section 18, my lord, of the act itself. It's an appealable order.
And only one indulgence, Lordship. Only 1200 square feet.
Appeal lies.
It will require for some time. He will take note.
Grateful. Grateful to your lordship. No, no, one place, my lord, your lordship has referred private from 6 to 16, or it will be 7 to 16.
It will be 7 to 16.
ওর দেখে নিও তো প্রাইভেট একটু দেখি বাবা একবার দাও ও বোধহয় নিয়েছে গৌরব নিয়েছে না
হ্যাঁ হ্যাঁ yes yes ma'am.
প্রাইভেট রেসপন্ডেন্ট হচ্ছে 7 to 16 আর মিউনিসিপাল কর্পোরেশন হচ্ছে 3 and 4 আর রেসপন্ডেন্ট স্টেট হচ্ছে রেসপন্ডেন্ট নম্বর 1 2
and 6
5 6 এটা একটু ঠিক করে দিও তো
Grateful.
The parties are not represented today? It was hard previously.
Yes, once it was hard. I have taken the point of
During the pendency of a liquidation proceeding, whether the proceeding can continue. Because the writ petition was filed in 2015. And the respondent company, that is West Bengal Tea Development Corporation, that company went into liquidation in 2019. In 2019, on behalf of the state government, an application was filed before the.
Give me a second, sir.
Lord, I have placed section 279, 280 and 283 of the Companies Act 2013 and submitted before Lord.
Just a minute, just a minute.
Yes, sorry. Meaning of order.
Okay. Prior to that, on 20, yes, maybe on 24th of March, thereafter 27th of March, then in April. তারপরে
একবার হয়েছে
ওই 9th এপ্রিল পর্যন্ত Lordship, in 2019, on behalf of the state government, an application was filed before the National Company Law Tribunal for winding up the company. Now, based upon that application, the company went into liquidation. The liquidator has been appointed. Now, after the liquidation process, the company went into liquidation. It was pointed out before this court, honorable court, during the course of hearing that presently the company is in liquidation. So now the company will be represented by the official liquidator. Accordingly, an application I filed, took out an application for adding the official liquidator as a party in the present proceeding. That application was allowed. And now since the company is in liquidation, the company is represented by the official liquidator. Now, during the course of hearing on the last occasion, my learned senior friend pointed out, referred some section from the Companies Act, which says that while the liquidation process is pending, no proceeding can be initiated or continued without the leave of the court. Now, the winding up process without the leave of the adjudicating authority, that is the National Law Tribunal, National Company Law Tribunal, the adjudicating authority. Let's see if I stand correct. Now it is in the hand of the
goes into the custody of the tribunal from the date of the order for winding up the company.
Yes.
And section 279 of the said Act of 2013 further postulates that no legal proceeding can be proceeded with by or against the said company under liquidation except with the leave of the tribunal.
Leave
That
of
is
the
your
adjudicating authority. Now, Lordship, that was the in 2013
Officer
Act.
Secretary is a custodian, but in effect, the entire assets and properties are in the hands of the tribunal. Obviously, is mere custodian.
No, Lordship, the proceeding that was initiated for liquidation of the company, that was under Insolvency and Bankruptcy Code. Lordship, I will rely which act has a overriding effect over and above all the acts. Lordship, I will rely upon and hand over the copy of the book. Lordship, excuse me, I have only one copy. Section 238 of the Insolvency and Bankruptcy Code. Lordship, may I just read the section 238 of the Insolvency and Bankruptcy Code 2016.
My Lord, only one submission. Perhaps my underpayment is not proceeding properly because winding up order was made on the basis of the Companies Act 2013, not in the IBC code. IBC
But
is
Lordship,
insolvency.
this particular act has
Highly-
overriding effect over
Yes,
the
no,
company.
that is not the statute.
Very good. Let him make his
Very,
submission.
very good. No, it is my duty to point out.
No, you will
Yes.
discharge your duty at the time of trial.
So that yes, sir.
Lordship, section 238 of the Insolvency and Bankruptcy Code says, may I just read out the section? The provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect by virtue of such law. This particular has a overriding effect over the Companies Act. Section 33(5) of the Insolvency and Bankruptcy Code says, 33 subsection 5, IBC. Powers and duties of liquidator. Subsection 1 says, subject to the direction of the adjudicating authority, that is National Company Law Tribunal, the liquidator shall have the following powers and duties, namely so and so. The subsection 5 says,
subject to section 52, when a liquidation order has been passed, no suit or other proceeding shall be instituted by or against the corporate debtor. Corporate debtor means the company. So no suit or proceeding can be initiated, provided that a suit or other legal proceedings may be instituted by the liquidator on behalf of the corporate debtor with the prior approval of the adjudicating authority. It is for the initiation, not for the continuation. This particular act has overriding effect over the Companies Act. This particular statute says regarding initiation, not continuation. This proceeding was initiated March prior to the company gone into liquidation. Subsection 6 says the provision of subsection 5 shall not apply to legal proceedings in relation to such transaction as may be notified by the central government in consultation with any financial sector regulator. This provision was introduced in the statute by the legislature with the intention that when a company is in liquidation, no proceeding can be initiated against the company after it gone into liquidation. So there is a specific bar regarding institution of the proceedings. The legislature very cautiously did not impose any restriction upon continuation of any proceeding which was initiated prior to the company gone into liquidation. Lordship, I have tried my level best to find out any, because on the previous occasion I submitted a judgment of Gujarat High Court of a single bench on the same, which specify that writ proceeding in the Company Act also it says that these particular provisions shall not apply in cases appeal pending in High Court and Supreme Court. There is an exception in the company laws itself. Whether the writ proceeding can be treated as exceptional clause of that particular provision or not, in support of that I submitted one judgment of a single bench of Gujarat High Court, but it was the desire of the court that I should come up with any other judgment of the Honorable Apex Court or division bench of our Honorable Court on this issue. But Lordship, I have with my best abilities I could search this is on the pattern this point by the National Company Law Appellate Tribunal. Lordship, I could not find any judgment on this issue of the Honorable Supreme Court. Lordship, this may I hand over the Lordship, this is 2024 SCC online NCLAT 856.
2024 SCC online.
online. It is with regard to NCLAT. Lordship, kindly come to paragraph 12.
No, prior to that, hand over the book first.
Yes, Lordship. May I just indicate the.
No, I have flag, sir. I have flag. Take this. Hey, flag lagi do. Hey, flag lagi do. জাজমেন্ট পরে দেখছি, আগে বইটা কি আছে দেখি।
So I have marked two portion, section 238, where the overriding
Section
effect
5
is
and 6.
33 subsection 5. That is a bar on initiation of proceeding during the liquidation process.
So liquidation order has been passed.
Yes, admittedly, liquidation order has been passed. Now the official liquidator is the custodian of the company and its assets.
But I will get that it has an overriding effect of.
I have marked two portion, 238, section 238.
No, Mr. Saha, according to Mr. Ghosh, Section 279 of the Act of 2013 postulates that no legal proceeding can be proceeded with or by or against the said company under the liquidation except with the leave of the tribunal.
Yes.
Now you are saying you are citing section 235, 238 of the code, which
238
says that the provisions of the code shall have effect notwithstanding anything inconsistent therewith contain any other law for the time being in force.
Yes.
I understand your content, sir. Now 33 subsection 5 says, subject to section 52, when a liquidation order has been passed, no suit or legal proceeding shall be instituted by or against the corporate debtor, provided that a suit or other legal proceeding may be instituted by the liquidator on behalf of the corporate debtor with the prior approval of the adjudicating authority. I understand.
Yes.
But why it has been
This with
stated
regard to the
that this
initiation.
court permits that there a proceeding which is pending against
But
a
there is
company which
no
has gone
bar.
into the liquidation, it will continue.
There is no bar, and Lordship, from the judgment which I have cited, I will demonstrate that the statute, the legislature very cautiously omitted this portion because this particular barrier was imposed for a particular reason, to protect the company once it is gone into liquidation, that no proceeding can be initiated without the leave of the adjudicating authority or the National Company Law Tribunal once the company gone into liquidation. But this legislature did not incorporate or put any barrier regarding continuation of any proceeding which was initiated prior to the company gone into liquidation.
Paragraph?
Lordship, paragraph 12 of the judgment at page 4. From the facts of the present case, it is clear that the Income Tax Department respondent appropriated the ITR amount on such and such by adjusting setting of the same against the CIRP income tax dues. This act of appropriation by way of set of adjustment was clearly undertaken after commencement of the liquidation proceedings on 25th July 2019. The first question for our consideration is therefore whether such continuation of pending proceeding is permissible after liquidation order has been passed. Lordship, that is the question involved in the present proceeding, whether this particular writ petition can continue after the company gone into liquidation. Lordship, kindly come to paragraph 17 and 18. Paragraph 17 at page 6. Thus, while moratorium under section 40 applies to CIRP, section 33 applies to moratorium in a liquidation process. A close examination of these two statutory provisions would reveal that both these sections are, however, entirely distinct in their sweep and application. In terms of language employed in section 14 and 33 of IBC, while section 14 prohibits both institution and continuation of proceeding, pending suits or proceeding against the corporate debtor, section 33(5) of Insolvency Bankruptcy Code is only a bar on the institution of new suit during the liquidation process, though the provision of section 33(5) further provides that if a fresh suit or legal proceeding is to be instituted, the liquidator is required to obtain specific permission and prior approval of the adjudicating authority. There is, however, clearly no mention of any bar or embargo on continuation of pending suit or proceeding during the process of liquidation. In terms of section 33(5) of the IBC, the moment liquidation proceeding commence, there would be a bar only in respect of fresh suit proceeding, while pending suit proceeding can continue. The liquidator can therefore continue to pursue or defend any already existing proceeding without having to seek any permission from the adjudicating authority in terms of section 35(1)(k) of IBC. In other words, though section 33 contains provision similar to section 14 contemplating stay on suit proceeding during liquidation, however, the reach and gamut of stay under section 33 differs from section 14 in that there is no moratorium on continuation of suit proceeding already instituted earlier. Paragraph 18 also specified to answer the question delineated at paragraph 12, we hold that the word continuation of pending suit or proceeding is cautiously omitted in section 33(5) of Insolvency and Bankruptcy Code, in contrast to section 14 of IBC, where it is explicitly stated that the moratorium applies both to institution of suits or proceeding or to continuation of pending lawsuits or proceeding against the corporate
Mr.
debtor.
Shah, I have understood your contention. Under the IBC, there is no bar.
Yes.
In continuation, in the continuance of the proceeding.
There is
Under
bar
the
on institution.
institution, that I have understood. But in another act, there is a bar. That is
Yes,
difficult.
that's why I
How do you overcome
pointed
that?
out that overriding effect 238. This particular has overriding effect over and above all other.
No, no. Had there been a contrary provision regarding say fresh suit or legal proceeding is permissible, then this code will apply. I understand. If you look at this, that is a 33 subsection 5. Try to understand what I am asking. Try to visualize the situation. If you consider section 33 subsection 5 independently, I believe it is your argument that there is no bar in continuance of the proceeding. There is a clear bar regarding institution of a proceeding.
Without the leave of the adjudicator.
And in the event any other act permits you to continue to initiate a new proceeding, section 238 comes into play. Am I clear up to this? Now, what Mr. Ghosh has raised a question that Companies Act prohibits continuation of a legal proceeding against a company on liquidation except with the leave of the
adjudicating authority, national company
NCLT. So, how this section or rather these two sections will help you? There is a bar under that act for continuation of the proceeding.
Yes.
If you look it independently and understand your continence, I understand your argument. But if both the acts are considered conjointly, wherefrom you will get this idea that this act practically permits you to continue the proceeding without looking to the relevant provisions of the Companies Act. That I intend to.
In case of repugnancy, if Lordship, in case of Companies Act says that.
No, Mr. Shah. Had it been such a case that the Companies Law permit you to initiate a new proceeding against a company under liquidation, this act will come as a bar because 238 will give you the answer. You can continue with the legal process, pending proceeding, but you cannot institute a fresh suit. But here the situation is just opposite. This section permits you to initiate, does not permit you to initiate a fresh proceeding. But according to you, there is no bar
in Insolvency and Bankruptcy Code.
In IBC to continue with the proceeding. I understand. And you have submitted a judgment to that. But that act creates a bar. Then how do you work on that?
See, that's why I pointed out 238, which is the overriding.
No, sir, 238 does not say something like that. What 238 says? The provisions of this code shall have effect, notwithstanding anything inconsistent therewith, contained in any other law for the timing in force, or any instrument having effect by virtue of any such law. What is the contrary provision in the
contrary provision of the Companies Act that no proceeding can be continued without the leave of the court?
No, that cannot be a contrary proceeding. Mr. Shah, that cannot be a contrary.
Lordship, may I come back after?
After vacation.
Not before that, my land friend, perhaps we are going through a misconception of law. Well, kindly excuse me for this. Kindly excuse me.
অর্ডারটা আছে লিকুইডেশনের
দেখাচ্ছি Your Lordship would kindly appreciate, so far my knowledge goes, so far Companies Act 2013 and the IBC Code 2016. Because the earlier Companies Act of 1956, in earlier Companies Act of 1956, in section 433, 434, 439, all creditors have the right to make application for winding up. Here, in the 2013 Act, the creditors has been totally separated. If your Lordship, may I say today?
No, he is seeking time. No, I
Oh,
don't
okay.
want to-
My lord, I shall argue on this point that
No,
my
no,
lord-
let Mr. Shah finish first. Thereafter I shall hear.
very well, very well.
Likhun, as per request made on
জুন হলো না জুন
My lord, I appear for the Madrasa Service Commissions.
item number
item
91 and 99.
But this is from item 90 to 99.
নাহলে ফি পাবো না নাহলে
My lord, I appear on behalf of petitions in item number 97.
দুটো
But these
matter কি
matters
হবে?
are specially assigned before my lord.
Just a minute, sir. 95 আসেনি মা?
Direction, my lord.
Oh,
My lord, well, there is an already interim order subsisting, my lord, till 30th June, my lord. But this matter pertains to my lord first state level selection test, my lord. 20,
I know,
my
I
lord,
know.
my lord.
My most sufferer are selected candidates. I am for the selected candidate. After that 1 decade, our age
But we are
50,
also selected
51,
candidates.
45.
অর্ডার বুকটা কি 93 রয়েছে? হ্যাঁ? কি তাহলে অর্ডার করবো কিসে? কি কারবার হলো?
ওরা ডিপার্টমেন্টে জমা করেছে ওই জন্য ফাইলটা চলে গেছে।
If Lordship wants to see the order, my lord, I have the soft copy. I can hand over my. Oh, for.
Number 90
Yes,
is the main file where the order has been recorded.
I understand.
That file is lying with the department. That is the difficulty.
ওরা ফাইল করেছে ওখানে
ঠিক আছে।
সেই জন্য
Perhaps,
চলে
my lord, due to
তুমি একটা কাজ করো,
reply has been
ওরা
filed in the
যাবে না?
department, my lord.
একটা ডেট করে করুন।
কি আছিস?
কবে করে? জুন মাসে দেখুন তো।
ডিপার্টমেন্টে জমা করতে হবে। ডিরেকশন ছিল। ডিপার্টমেন্টে ফাইল কর।
ফাইলটা আনান, ওটা একটা অর্ডার করতে হবে তো, নাহলে ওটা নিয়ে এসে তারপরে অর্ডার ট্যাগ হবে।
91, 99 10 জুনের পর নাকি?
দিন
খুলছে কবে আমাদের 10 জুন
9 June.
9 জুন
না হবে না।
কবে দিয়ে আছে?
17 জুন 18 জুন 18 জুন
Do your Lordship keep on 23rd any?
16, 17, 18 IP5 fixed consecutive dates from 2 p.m.
16
because
17th is
No, no, 16, 17, 18. I am fixing all three dates.
all these 3 dates.
Yes.
Thank you. Carefully.
Just like a schedule in a
Yes,
sessions
yes,
case.
yes,
Only today on 16th in court number 26 presided over
Then 17, 18, I want consecutive dates. 17, 18, 19.
19.
17, 18, 19, my lord.
Yes,
My
yes,
lord.
yes. My lord, 17 and 19.
এটা লিখে নিন আমি ফাইলটা আনি as per request made at the bar.
On behalf of the petitioner, my lord, we have not filed a reply, my lord. Therefore, my lord, kindly grants us the liberty to file reply to the affidavit of
আবার
opposition.
টাইম হয়ে যাচ্ছে আবার দেরি হয়ে যাচ্ছে
My lord, within that time, my lord.
আচ্ছা ঠিক আছে লেআউটটা লিখে নিন তো affidavits in reply affidavits in reply if there be
Having the copy of the affidavit.
keep it. File is not here.
File নেই
This is a difficulty.
খালি
17, 18, 19, হ্যাঁ।
ওরা ডিপার্টমেন্টে জমা করেছে
হুম? 17, 18,
ওই দিনকে না ওই নোট করে রাখো তো মাদ্রাসা ম্যাটার বলে নাহলে আমি আর ওদিকে কোনো মামলা রাখবো না একদম নোট করে রাখো ডায়েরিতে মাদ্রাসা ম্যাটার 2 PM আর কোনো ম্যাটার রাখবো না Can 4 of 2024. What is that?
Desperation application, man.
What is your affidavit of service, sir?
Direction of the pilot.
কি আমি তো আছি তো
ও ওই no, no, আমি আছি। তোমাকে দেখতে পাই
When it was dismissed.
it was 16th July 2024. Paragraph 3.
Arjun bhai, can 4 of 2024.
I am having my transfer. My lord, opposition has been filed. আমাকে একটা copy দিয়ে দিও তো। Your lordship kindly fix up a date, my lord. I will take a copy of my opposition, my lord, and I believe their reply has also been filed. তোমাদের reply দেখো আছে কিনা? তাহলে একটা reply ready করে নাও।
reply দেওয়া আছে।
দেওয়া আছে? Yes, my lord. Reply is also here.
reply argument completed. This is a service matter.
Yes, service matter. Removal from service
Permission.
as against the charge only
দেখুন
single
এবার
charge.
WPA তে লিখুন WPA 1784 Yes. Can 1 of 2024, what is that, sir?
On the last day, it was mentioned by you, assigned. That I have just take the record and show it to you.
কি বলছেন উকিল বাবু দেখি?
Matter sub.
No, what is can 1 for?
Oh, that is WPA number A. WPA 3527.
Oh, what is the interlocutory application for, sir?
Restoration, sir.
Restoration.
এটা দিয়েছেন এটা?
ওটা কি আছে দেখাচ্ছেন?
Oh, you're saying on that day you are told that this assigned matter let us see.
Huh?
This matter was taken up on
WPA 3527 of 2023. এটা আমাদের কি ডিটারমিনেশনের মধ্যে পড়ছে?
Listed on 5th January on item number 12. That I have given.
No, hearing of writ petition up to 2013 to 15. এটা কি আমার কাছে অ্যাসাইন হয়েছে? হ্যাঁ?
On that day you have told me, sir.
সে কি করে বুঝবো? কি আছে দিন আমি বুঝতে পারছি না। It was assigned to some other bench.
Later on it was placed before your answer. On that day you have told me, on that day. So filing the assignment.
বুঝবো এটা আমার কাছে অ্যাসাইন হয়েছে? What is the order of the assignment?
That order I have not received. It was listed, sir. Initially it was on 5th January, it was not taken up.
No. I have determination for hearing of writ petition irrespective of classification, including application connected to up to 2015. It is a land matter.
Land matter.
Huh?
Land matter.
তাহলে এবার অ্যাসাইন বলছে কেন?
On that day you have told me, sir.
বলছেন আমি বুঝতে পারি না।
No, on that
It is a land matter.
Land matter.
The affidavit of services filed today লিখুন দেখি দিন ওই রেস্টোরেশন অ্যাপ্লিকেশন সে আবার নেই can 1 can 2 আছে তো।
Two, my lord, I am appealing for the petition.
Then why not responding, sir?
Sir, I was coming from Kotum.
Huh?
39, my lord, I was late. I am extremely sorry for that. This is an application for restoration, and there is a section 5 application, my lord. This is the affidavit of service.
নেই দাও how many days delay?
There is a 1 month and a half month delay, my lord.
In which paragraph you have stated why there is delay?
Sir,
Who was ill?
yes, my lord.
Who was indisposed of?
Petitioner was the petitioner who made the affidavit, my lord. He was ill at that time, so that's why he couldn't come, and that was the reason. That's why I explained in paragraph
Is there any private respondents?
6. No, my lord, no private respondent. Paragraph number 6, my lord.
The affidavit of service. Why two affidavit of service?
Because, my lord, the restoration application also I have served, because in the previous advocate has seen that was
Look, two
dismissed on the
numbers of affidavit of service. by issuing a notice in writing, huh?
Okay,
Next date.
They have appeared, man.
Even then you intimate.
Okay.
I have not recorded, which is why I have not recorded. But for your interest, I am requesting you to intimate.
But I appear for the respondents in this case, my lord.
Instruction to appear on behalf of the respondent number 6 and 7, but no copy of the CAN has been served up to my client. I am told that my petition was disposed of. Probably they have filed an application for modification, as it appears for.
Well, I appear for the respondent corporation.
Sub copy.
Well, I am respondent corporation. I have not filed this application.
Petition is not appearing also.
I have
Who
not.
are you then?
I am for the private respondent 6 and 7.
Petition only,
This petition is not appearing.
because this is a misconceived application.
The
Dispose of
representative
matter.
the representative is not represented.
I'm for the application. The restoration application filed within the time.
Henceforth, I shall impose cost for restoration. Why are you not present at the time of hearing?
Madam, for the state, my lord.
What reason you have assigned?
The engagement in another court, your lord.
Huh? Unnecessary wasting the judicial hour. Ligun, Can 1 of 2025. The writ petitioners and the respondent state and its functionaries are represented by their respective learned advocates. Stop.
My lord, I'm for the petitioner, my lord. I have to take some instructions, my lord, regarding the new updates and
On behalf of the writ petitioner, an accommodation has been prayed for. Prayer for accommodation is considered allowed. Let the matter be listed in the month list of July 2025 under the same heading.
I am for the state, my lord.
Lord, in earlier occasion, this matter was taken up. Lord,
By this court?
no, no.
By a coordinate bench? Then why are you saying this?
Lord, I
Don't embarrass this court.
no, no, no. They are,
This court or they are.
Lord, some direction was given. My lord, I am just submitting that.
Oh,
There, my lord, direction was given, my lord, to file a report.
give me a second. Report filed. Very good.
Now, my lord,
Give me a second. Give me a second, sir. Sir, I am not so fast like you, sir.
no, 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 Lordship, kindly. I think this report
দেয়া হয়েছে আপনাদের
আমাকে দিন।
এই যে in form of affidavit.
The construction is going on where?
My lord, construction.
Who is for the respondent?
I am for the state, my lord.
Private respondent is there.
No, no.
Yes, sir. Make your submission.
Lord,
What is that?
my lord, report was there. They have given the copy of the report. First, my lord, at the time of first hearing before the court bench, they have submitted one report. Therein, my lord, that report was, my lord, filed by the concerned BLRO, my lord, and inspection was made, my lord, my lord, since that inspection, my lord, was made, my lord, in the, my lord, without service.
Be that as it may, now report has been filed.
Subsequently, a report was directed to be filed. That report has been submitted.
What is that?
Lord,
Exception.
Exception.
Give it.
Lordship, kindly consider.
Now place your case.
Yes.
Forget about the introduction. Just come to the point.
So
what is your prayer?
what I was submitting, Lordship, kindly consider the earlier order passed by Justice my Lord Subra Ghosh. There, my lord,
Order dated, sir?
Subra Ghosh. My lord, that order, my lord, Lordship, kindly consider. Lordship,
22nd November
kindly
2023.
consider. My lord, 10 January 2024. আগের দিনে অর্ডারটা জয়সের কাপুর এটা তো দিয়ে
ওটাও তো না বললো না তখন তুই বলাবে দেখলে তার নেওয়া উচিত না কে কেনাই থেকে ধরতে হবে ও দাঁড়া কি করছে তোদের দিও না কি করছে এরকম করছি কেন নিজেদের বলছি যার সঙ্গে এরকম শুনছি করছে সাপ্লিমেন্টারি দিয়েছিস তোর সঙ্গে কপিটা দিয়েছিস এটা কাকে হ্যাঁ না না
So joint field inquiry has been done.
My lord,
Senior friend.
may I take it, my lord?
Yes, sir.
সিঁড়ি ভেঙে গেছি totally private my lord আমার জন্য বসে থাকবেন তো হবে না no my lord again there is a I'm really surprised the spirit of the order is very clear initially a wrong was committed by the authority it was the desire of the court should be done by the DM
Done by the
DM for obvious reasons now
where is that order?
কোথায় সে order?
Order dated and Purusha Joseph.
Order dated 10th January, right? 10th January.
There is no whisper that the inspection will be done by DM.
Yes.
No whisper.
My lord? No. Finally, see, in view of, yes, in view of the above, DM personally cannot do that in presence. In view of the above, where has got it, my lord?
Second page.
The second page. This court is inclined to hold that since the petitioner alleged construction of 13-feet wall adjoining the plots, thereby blocking the only ingress and egress, the concerned authority being third respondent herein, who is that? DM, District Magistrate. Be directed to take necessary step for holding a joint inquiry inspection. Can you see? Apart from that, this is the trend of the day. They think High Court judge is nothing. I'm sorry to say, and as being a government pleader, I just repeatedly one additional government pleader is sitting over there.
No. Then what happened?
And everything is done.
Joint field inquiry was done.
That was done, and
At the instance of the BLR.
Report was submitted.
at the instance of the BLRO. Apart from that, kindly knows, my lord knows better than me, vast experience.
No. Third respondent be directed to take necessary for steps for holding a joint field inquiry in this regard.
Yes.
That has been done or not? That I intend to know.
Inquiry is done, but by whom? By whom? BLLR. Let them file the report.
So what is the wrong in it?
How that can be? If you will also direct me, Mr. Ashok Banerjee, you must carry the order. I'll do that.
No. Third respondent, the district magistrate.
Yes.
Be directed to take necessary steps for holding a joint field inquiry.
That's true.
Can you see page 4, my lord, of my report? Paragraph 3.
Page report of?
Report of the respondent number 4. Page 4, paragraph 3.
Page 4. Report. এটা আমরা এক্সেপশন দিয়েছি তো কোর্টে বার কর কোর্টে বলছিস প্যারাগ্রাফ 3 a joint field verification has been conducted by the deputy magistrate Tamluk
Block development officer.
Page number?
Page 4.
Page 4, Roman 3.
Supported by affidavit?
Affidavit.
এটা কোথায়?
এই ওটো দেখো যা সব খুঁজছেন ওটা বার করে দাও
Yes, I got it. দেখি এটা দেখি একটা এই ফ্ল্যাগটা দিন না ওগুলো সবটা দিয়ে দিন আমায় Yes. Page?
Page 4, para 3, Roman 3. Have you got it, my lord? Yes. A joint field verification has been conducted on such by the deputy magistrate Tomluk. He is not the magistrate anyway. Block development officer Tomluk development block or such and such of the block officer. The inquiry team has found that the field position as mentioned in the earlier report has remained same till date. So earlier report which was filed that was not accepted by the court. Because of that, well, BLRO did it. Then specifically the court directed under the supervision of the DM and deputy DM is done. But apart from that, my lord, this is a practice. Nowadays they are doing, they think they are above all. This is not a fact. Fact is there cannot be a landlocked. I have taken an exception against that.
No. District magistrate was directed to take necessary steps for holding a joint field inquiry report. It does not say that the
he himself will do that. Very well. Then what was the need to be present the deputy magistrate? Consciously that was done. But anyway,
Mr. Banerjee, place your case first.
Anyway, I'm not. My lord, landlocked land It cannot be. There is a law, basic and fundamental law. I have taken the exception to that.
No, Mr. Banerjee, what is your grievance?
I'm coming. I have
Yes.
taken the exception to the report.
Very good.
It will be reflected from that. Can you take trouble? The exception to the colored pictures are also there.
Mr. Banerjee, why are you starting from your exception? Why not starting from your read petition?
That will reflect it from the report itself, reply itself, everything. That will save you lots of valuable time. I can continue for 2 days, my lord. That is not proper.
No, I will not allow you to continue for 2 days.
I'm grateful, my lord. I'm grateful.
Your read petition does not depict a good case, which is why you are
Very good
relying
case.
upon
Very
it.
good. Very good case. Very good case. Very good case.
Very good place. It.
Then kindly see. Admittedly, I have
I
purchased.
do not know what is your prayer right now.
Admittedly, I have purchased a plot of land.
What is
Right?
your prayer? You read in the nature of mandamus commending the respondent such and such not to make the construction of the boundary wall by stopping the ingress and egress of your petitioner
That's all.
from their premises to go to the link road
Hmm.
through such and such,
Yes.
and the nature of mandamus as pavilion space open. Very good.
That is the main pair. So what is actually, that is why I just wanted to draw your losses at kind of understand, because the pictures are there, my lord, to understand everything. That is a pair. Very good.
Make your submission in your own way, sir.
My lord, the whole thing is this, my lord. Kindly take trouble 1 second. The report. Reply to the report. Or copy to go
Exception.
Exception. I'm grateful.
Yes, sir.
The pictures also there. Very rightly, my lord, put this question. What is your main pair? That is my pair. My lord, I need not trouble you also by placing 2, 3. My lord, so far 3, my lord, say, Mr. Manji, forget about that. The additional distribution. Then 4. That thereafter in complete. Paragraph 4 onwards. That thereafter in complete violation of the said order of the block land and land officer Tolukan, by his letter dated such and such address to the additional executive officer Purvo Mednapur Jila Parishad, informing him that the desired demarcation of land being having plot number 410 and 411 would be held on such and such date at such and such son and such and such, wherein he was cordially requested to instruct his representative to remain present on the scheduled date of time. The copy of the said letter was forwarded to the petitioner to remain present on scheduled date of time. Accordingly, on 15/12/2024, Revenue Inspector, along with some persons claiming to be the official litigations and Waters Department, as well as the representative of the additional executive officers, Purvo Mednapur, came to conduct the joint field inquiry in presence of the petitioner. That by the very beginning of the such an inquiry, your petitioner objected about such joint field inquiry at the instance of the revenue inspector, since the Honorable Court has specifically directed the District Magistrate, Purvo Mednapur, to take necessary step for holding joint field inquiry, which cannot be done by lower level revenue inspector, but the said revenue inspector shown deaf and request. Your petitioners also submitted that in the self-same cause of action, earlier block land and land officers caused a joint inspection wherein the Honorable Court was not satisfied and accordingly directed the district. Kindly see, this is the first time. Earlier, the same person made an inquiry. Then we challenged before Justice Subra Ghosh. Mrs. Ghosh, Justice Ghosh was very much annoyed. How is it? But the court was not satisfied, accordingly directed the District Magistrate Purvo Mednapur to take necessary step for holding the joint inspection, but such inspection is being carried out at the instance of the revenue inspector in the office of the block landed officers, Tamlukan, which can be sustainable on the strength of the order in Sansat passed by the Honorable Court. However, the petitioner showed the inspection team the sanctioned building plan of Purvo Mednapur. Is in my paper. Purvo Mednapur Jila Parishad, wherein in the northern side of the building, a drain followed by a concrete link road, which leads to NH 41 to the administrative building for ingress and egress of plot number 410 and 411, but the inspection team paid no heed to the petitioner building plan. Your petitioner further submitted before the inspection team that there were permanent road which the petitioners were using for long time for ingress and egress to plot number Sansaj, which has been blocked by constructing 13P wall, stopping their ingress and egress. This is the crux of this case.
So you are seeking any easement right?
No. Already there is a road. And based on that, the Parishad granted me the sanction plan. I have constructed on the basis of sanction plan. It is not the unauthorized construction. So I started using that road. Now, very peculiar stand is taken by the authority. You have got an alternative road. I'll come to that. Can you see the next paragraph? That the concerned revenue
Your
officer
petition further submitted that before the inspector there were permanent road which the petitioners were using for long time for egress and ingress to plot number 410 and
right,
which has been blocked by constructing such and such.
so if that the road doesn't belongs to any other person, road is public road, which is attached to my plot. So I have every right to, based on that plan of sanction, am I clear to losses, my lord? Then paragraph 8, that the concerned revenue inspector without making any inspection asks your petitioner to sign in a blank sheet, and as such your petitioners have denied to put their signature in the blank sheet. The revenue inspector further asks the petitioner that there is a clear way of, very relevant, Kali marked it, my lord, clear way of ingress and egress to that building through plot number 409, but he along with his team did not consider the plot 09 is a private land covered with many multi-story building, such as Kali marked it, very relevant. He advised me to use that particular land. And by land doesn't belongs to me, belongs to others, and there's already other buildings are there. Such as that Hotel Raj, in which they have no free access, and the same will be clear from the hand sketch map of the situ land and the photograph which are annexed here with marked with letter A. Kindly come to the picture, my lord. Then I'll read the next part. Kindly see the pictures, which is very relevant. Have you got it, my lord? This is actually, my lord is looking to this one. Kindly see. Then, my lord, where is 408? He refer the 408.
What is 408?
408 and 409.
409.
409. And paragraph 409, paragraph page 5 at top, 409. 409, my plot is 410, yellow color. Have you got it, my lord? Just below the link road to NH National Highway. This is a link road. 410, my land. Just below the 4010, 409, that belongs to Hotel Raj. How he can advise me? Use the Hotel Raj land.
What the construction is going on?
Now come to the next photograph.
No. So far as this plan is concerned.
Yes, that is also there. Just above 410. Kindly marked it, my lord. Below the link road to NH. Have you got it, my lord?
A blue strip.
The marking is there.
A blue strip with this there zigzag.
Zigzag.
That is the construction.
Wall. This is a boundary wall.
No, what is the approach road to 410?
Just attached to 410, link road, and then kindly see the mark, black mark.
Mr. Manager, I understand your contention. So far, 410 is your plot?
Absolutely correct.
According to you, just above that is at the northern side, there is a zigzag red blue strip.
That is a wall.
This is the construction. According to you, prior to construction of this wall, which road you are using?
Kindly see, this is the entry. This small black portion for in case egress. Then I am reaching to that link road to NH.
Yes.
Have you got it, my lord?
So, according to your access to plot number 410 has been blocked on account of construction of this wall. What is their stand?
Now their stand is you can use the other alternative road is there. I'm reading that. 409. Once again, Kali come to
it is your submission. What is their report to that effect? You are reading your exception.
That is the report, Hotel Raj. Hotel Raj, you can use that road. I am not the owner of the Hotel Raj. How can I use their road?
No, I will get that, sir.
Yes, I'm kindly come to their report.
Page 3, paragraph 2.
Kindly see, Hotel Raj.
At the field, the inspecting team found that
There is an existing increase and egress. Paragraph Roman 2, page 3. Their report. At bottom. Have you got it, my lord? Bottom. At the field, last 3 lines. At the field, the inspecting team found that there is an existing ingress egress on the front side of that hotel, namely Raj Hotel, and the proposed boundary wall going to be erected at the back side of the Raj Hotel. What is this, my lord? This is property of X. I am the owner, I am the Y. They say there is a road, you can use it. Are bhai, who are you to advise me? Originally, land belongs to us. Subsequently, that was acquired, a portion.
The block level jointed Atho.
Yes.
The field, the inspection team found that there is an existing ingress and egress on the front side of that hotel, namely Raj Hotel, and the proposed
Raj Hotel
wall going to be erected at the back side.
So what are we to do? They may have several ingress and egress.
What?
How is it? Have you got it? Can you see that stage map? Hotel Lodge 409. Hour is 410 and part of 411.
No, according to you, the owner of plot number 410 will use which road?
plot number 410.
You are the owner of the plot number 410.
410 and part of
Where is the access to plot number 410? That I intend to know.
After investigation, it is found that there is existing ingress egress on the front side of the hotel, namely Raj Hotel.
Raj Hotel এর সঙ্গে আমার কি আছে? আমার দেবে কেন তারা? কি আশ্চর্য? So I'll use that for passage of Raj Hotel.
And the proposed boundary wall going to be erected at the back side of that Raj Hotel.
Obviously, just attached to my plot 410. They're trying to put it in the whirlpool and confusing trying to create a confusion.
No, from this case map or from your report, can you show that there is an alternative egress and ingress
of the
petitioner in plot number 410?
I'm
That I intend to know.
I'm deeply obliged.
এটাই তো বোঝা যাচ্ছে না কি যে বলে বাবা বুঝি না
সেটাই তো হচ্ছে মুশকিল দেখুন না কি উল্টো পাল্টা বলে যাচ্ছে আমি দোষ দিই না ওকে অ্যাডভাইস যা দিয়েছে তাই করেছে 410 411
An acquisition proceeding was initiated in this record including other land for construction. Thereafter, he started construction, but the petitioner alleged the respondent authority obstructed the egress and Atho to go to the link to connect it to the NASA. Subsequently, the petitioner made several representatives. After receiving the Atho, respondent authority stopped the construction.
One thing I must finally confess, I don't want the entire wall to be demolished. Only 15-foot passage.
In presence of the representative Atho at the field, the inspection team found there is an existing egress and instead on the front side of that hotel. Front side means which side? North, south, east, west. How can I learn?
Nothing.
Key report over.
এই তো মুশকিল হচ্ছে
going to be erected at the back side of the. So your plot is 409.
No, 409 is a hotel.
Oh, 410.
410 and part of 411. Because other part has been acquired by the government, I don't mind. It is government needed to do that. I must finally confess.
So where from you will get in 410? That I intend to know.
My lord, may I submit one thing? Kindly give me 1 day time.
Hey.
And I must finally confess, my lord. I don't want the entire wall should be demolished. I want only empty and access.
15 time.
Only 15 feet.
Who has prepared this report?
Respondent number 4.
না
হ্যাঁ?
additional district magistrate.
না না ও কি কোথায় হবে?
রিপোর্টে কে করেছে?
বললাম
চন্দ্রানী ভট্টাচার্য ডক্টর অফ রিপোর্ট ফ্রম দ্য
annexure টা দেখুন annexure।
আর না না রিপোর্টের নাম এই তো চন্দ্রানী ডেজিগনেশন কি? ও এ হচ্ছে ওয়ার্কিং ফর গেইন এট দ্য অফিস অফ দ্য ডিস্ট্রিক্ট ল্যান্ড অ্যান্ড ন্যাপ অফিসার যাচ্ছিল। তাহলে এই কে স্ট্যাটাসটা কি?
ডিএম অফিসে কোনো একটা স্টাফ
না না staff না এটা BLO।
আরে দেখো ভাই তোমার অ্যাবিলিটি দেখো, চন্দ্রানী ভট্টাচার্য ডক্টর অফ সার্চ অ্যান্ড সার্চ বাই অকুপেশনাল সার্ভিস ওয়ার্কিং ফর গেইন এট দ্য অফিস অফ দ্য ডিস্ট্রিক্ট ল্যান্ড অ্যান্ড ন্যাপ অফিসার। হোয়াট ইজ স্ট্যাটাস? হোয়াট ইজ স্ট্যাটাস? কি ডেজিগনেশন? Whether she was present?
পরে প্যারাগ্রাফে কিছু বলতে
I am the authorized person responsible for.
অথরাইজ
কি করে অথরাইজেশন হলো? তার ডিস্ট্রিক্ট ম্যাজিস্ট্রেট।
না 3 তো ডিস্ট্রিক্ট ম্যাজিস্ট্রেট।
3 4 কে 4 করতে পারে না, অথরাইজেশন ডিস্ট্রিক্ট ম্যাজিস্ট্রেট করতে পারে।
ওর বিএলআর রয়েছে
বিএলআরও আরো ডেঞ্জারাস।
Ask BLR to come. Otherwise, he will not be able to understand.
বিএলআর তো
He will demonstrate where from the writ petitioner will get access.
Matter ends there. I must finally confess, my lord, I don't want entire world to be demolished. That is impractical. Kindly see, my lord, against that picture once again. Kindly have a look. Only this portion, this portion. I can go over the text also. I need not. Just above plot number 410, black mark, my lord, in the middle portion.
No, if I, for the sake of argument, try to understand. If I accept the contention of Mr. Banerjee's clients is absolutely correct, this is 410. Just come to this.
Right. Yes.
On the northern side, there is an allegation they have made a construction. So this portion is blocked. Am I correct, sir?
Yes.
Now left side, there is a western side. There is a 402 is a building.
Building.
And you have on 411, it belongs to you.
No, part belongs to me, part already acquired.
Then then where from? And at the south, there is Raj Hotel. So where from will get entry and exit?
And I can't use
Ask
the
BLR to come. Stop. Ashun.
Get me one chance.
Let him explain. Let BLR to explain. He is not able to understand. The exception
I'm sorry.
Only pretty good. But the representative of your client, when your clients are hired you, it's expected that you will get proper instruction from the at least from the back, from the back. You will be able to take care of the law parts. That I understand. But for the factual, because the clients are the master of facts.
They will suffer for us.
Can I not have? And what does statement?
None appears on behalf of the writ petitioner. Pendency under that heading throughout this month, so that the people can watch. এগুলো কিন্তু শো করা হবে, বুঝেছো তো?
We are appearing. We are appearing on behalf of KMD Lordship along with Mr. Satyajit Talukdar Lordship. His mother has expired, so I'm praying for an adjournment.
Still in morning.
Yes.
Then Lord kindly makes it after vacation.
Of
Lord,
course.
because this is a hearing matter, it will take some time. But may we file Lord the supplementary affidavit and the affidavit of service?
An exception to the report.
But it was given to you for filing supplementary affidavit.
Yes.
And to file the
And an exception to the report, Lord, is also there.
There is order.
In order to that, order take to work on. Yes, Lord, 23rd of August 2024.
সার্ভিস করে দিয়েছি
সার্ভিস করে
yes yes affidavit service
affidavit of service করা হয়
আমার নাম
হ্যাঁ আচ্ছা আচ্ছা না থার্ড সেপ্টেম্বর দিয়েছে
ঘরের লোক
হ্যাঁ না না দিয়ে দিয়েছে না
It's a supplementary affidavit, accessible to the rules.
After vacation? No, 1 week after vacation, Rako? 1 week after vacation.
Readings completed.
Sad to achen both.
On the last occasion, on the prayer of the on 5th November, on the prayer of Mr. Talukdar learned advocate appearing for the respondent number 5, time to file counter affidavit stands extended till today. Counter affidavit filed today in court is taken on record. That means you have served a copy.
Yes, supplementary copy was served on 3rd September 2024.
Sorry, I fail to understand.
Lord, the supplementary leave was granted by the order that Lord 23rd of August.
That I have seen.
We have Lord before Lord 30th, Lord that was not affirmed. Copy was given to Lord Mr. Talukdar as well as Mr. Dey on 3rd September.
Which is why he has filed the counter affidavit.
he is supposed to not reply to my supplementary affidavit by a counter affidavit.
That is an opposition to my supplement.
No, then why it has been written? The time to file counter affidavit stands extended till today.
It is not in the way of affidavit in opposition to the supplementary affidavit.
Then it has been recorded counter affidavit filed today in court is taken on record.
Yes, that is a
What is that?
opposition to the supplementary.
That is the opposition to the supplementary affidavit.
Which is going to be filed today.
No, that supplementary is mine. And Mr. Talukdar's not what he is filing is not the opposition to my supplementary affidavit. That is already on
এটা
record.
উকিল বাবুকে একবার দেখাও। উনি বোধহয় আমার কথা ঠিক বুঝতে পারছেন না বা আমি বুঝতে পারছি না ওনার কথাটা।
হ্যাঁ ঠিকই আছে।
Counter affidavit ঠিকই আছে।
It is counter affidavit to it is counter to which?
Supplementary.
Counter affidavit on behalf of respondent number 5 to the composite supplementary affidavit. The composite supplementary affidavit is not this one.
That I am saying that you are going to file.
Yes.
A copy, advance copy of the same has been
Already given.
That I am saying that.
Yes, to that effect, not the affidavit of services.
I understand, which is why I am asking. Since it has been served earlier, which is why he made it ready and filed it earlier on the account. বুঝেছি চলো লিখুন on behalf of the
and not property. My property is a separate property.
But they are using the same.
They are claiming it to be not vested to the land by acquisition.
According to you, it has been wrongly used by them, for which you want that an acquisition proceeding be started and you want a compensation.
No, we say, I want that they should be removing their boards from my property because my property is not part of their acquired property.
That is the subject matter of Can, sir.
That is subject matter of the writ petition also.
Then what is the subject matter of Can?
Can is, my lord, that they have fixed, my lord, a board in my property. I say that you have to remove the board because that is my private property, not an
Sorry, sir.
acquired property.
In the prayer portion of your writ petition, there is no such prayer for removal of the board.
Because that happened later on.
Naturally.
Because that.
What's your main prayer then?
Main prayer is, my lord, that kindly remove yourself from the property that I am occupying. That is a non-acquired property. Or you pay me compensation if you want to occupy.
That I intend to say. Very good. Achha. Let the instant application be listed. It cannot be dismissed.
Today I got a chance to kindly accommodate me, kindly give me some relief, at 2 p.m. Kindly, there is an honest request to your lordship.
Not within 13 minutes, it cannot be disposed
not
of.
today, not today. 1st July, 2 p.m. If you are subject to your lordship, kind.
1st July, I am telling.
At 2 p.m. Kindly make it at 2
Fix it another matter, not 1st July.
So 2nd July, 2 p.m.
No, on 1st July. Keep it on 1st July under the severity.
I'm getting.
Mr. Pan, I am trying my level best to dispose of the cases.
I fully appreciate, no doubt about it.
Yeah, sir.
My lord, in 110 appearing for the petitioner, my lord, led by Sir Warza.
I am for the respondent number 8, my lord. The parties are represented. The parties. Devotion. What is your prayer in Can 3?
Prayer is that for allow this amendment application, my lord.
What is the schedule of amendment?
My lord, in the schedule paragraph number 1. And 1 to 3, my lord.
What is your instruction? You want to file
Today-
any?
Today I have received the application, my lord. Kindly make it after vacation. I'll through the application.
আসুন কি লিখেছি বাবা? 110 with 11 একসঙ্গে অর্ডার হবে হ্যাঁ
My lord, I am appearing only 100 item number 110, my lord.
ঠিক আছে আপাতত তো 10 with 11 তো অর্ডার করা আছে there is an order of tagging I believe দেখি দাও তো একবার অর্ডার সেটটা then why it has been tagged
The previous
অর্ডার বুকটা দেখি অর্ডার বুকটা দেখি
check, my lord.
Huh?
Previous order, it was checked. In the previous order, my lord, it was checked. The item number.
let me see no there must be a order of tagging
Yes, ma'am.
this writ petition was directed to be heard এত একটা কাজ করো তো বাবু এইটাই না এইটাকে এইভাবে করো WPA 20440 তেও এইটা করো আর এবারে WPA 21272 of 2011 করো মানে আলাদা আলাদা করে অর্ডার হবে the parties are not you are for the state
I'm for the respond number 8.
in the number
110.
that is 21272 you are also appearing
I have instructed in
no you are appearing in WPA 20440
20440.
Fajal Nusa
Yes.
and you are appearing in Pranati Mondal's case also
Pranati Mandal.
both
No. I am instructed from the respond number 8 Pranati Mandal that today is the
My lord, he is appearing only for item number 110.
yes.
Proti Mondal is appearing on the respondent number 8, my lord.
Yes, my lord.
you are in item number 10 or 11
Item number 10.
Number is the petitioner হয়ে আছে।
Both, my lord.
she will give you instruction
No, my lord. I did not.
লিস্টটা দাও বলে ব্রিফ টিপ কিচ্ছু নেই ও চলে এসেছে নাকি
Today I have received the application, my lord. That's why.
your client is Fajal Nusa
My lord.
in Pranati Mondal's case you are appearing
Both the matter I am appearing.
say that I am asking for that
Yes, ma'am.
কি লিখলাম বলো তো না ওটা তো হয়ে গেল এবার হচ্ছে none appears on behalf of the writ petitioner however WPA 20440, then you must appear on behalf of the Pranati Mondal in writ petitioner in 21272.
Yes, my lord.
আচ্ছা ওইখানে তাহলে লিখে রাখো learned advocate for the writ petitioner is hereby আরে ভাই এটাই যে পিটিশনার ওটাই সে প্রাইভেট রেসপন্ডেন্ট
Yes,
এই দেখো না এই যে ফজলের নুসরাত আছে না এই দেখো এখানে প্রণতি মণ্ডল হচ্ছে প্রাইভেট রেসপন্ডেন্ট
Yes, ma'am.
আর এখানে দেখো হচ্ছে প্রণতি মণ্ডল হচ্ছে রিট পিটিশনার তার মানে উনি হচ্ছেন প্রণতি মণ্ডলের অ্যাপিয়ার করছেন তো তাহলে এখানে প্রাইভেট রেসপন্ডেন্ট কে এখানে প্রাইভেট রেসপন্ডেন্ট হচ্ছে এই যে ফজলের নেশা একই তো হচ্ছে উল্টে গেছে ঠিক না বলতে পারলাম কি করে বুঝবো বলো তো আমাকে ফাইল থেকে বার করতে হচ্ছে হোয়াট ডু ওয়ান্ট
in item number 110.
you serve copy of the notice you serve notice along with the server copy of this order
Yes, ma'am.
let the state respondent appear thereafter I will allow you to serve
Yes.
it will for your benefit
Yes.
10 June চলো 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 টাকা।
বলবো
Mention
কেন দিবেন স্যার ফিক্সড করে দিই ওই এমনি হবে ছুটি পরে করবি
Friday after original sign
So let there be indication in your lordship.
Friday
ওটাই ভালো তো ফ্রাইডে মেলা adjourn motion then motion
কি বলবি
Friday original sign mandate motion thereafter adjourn motion thereafter motion